Hello, hello, guys. Hello. Long time no see. It's been a couple days. I'll wait until we get a few in here. We have some letters that we are able to present. All right, guys, just pulling it all up here for you guys. All righty. So as you guys see, as the title, it is letters. Some letters had to get prepared to be able to go out. There's been a lot of new information that has surfaced, that has been going around. And also there has been a lot of more information that has been released, especially on one of the lay witnesses that was taken into custody straight from the hospital, which had occurred over this weekend. Anticipated. Hello, Pamela. How are you? Long time no speak on here. It's been a few days. We have some letters that had to get prepared to be able to be served and go out, so it can reach all the parties that it needs to go to. Did look into several things in regards to Jeffrey, and also for Diamante, it would apply to him as well. Several of the defendants. Yes, Pamela, a lot going on this weekend. A lot of research had to take place. A lot of letters had to go out at the end of last week. I had a pretty eventful weekend, making sure that I was doing my part in going through the things that I needed to be able to prepare everything the correct way. What I did find is that there is a very fine blurred line between a pretrial detention center and a prison. And for Georgia, each has its own set of rules that they must abide by. And you run into that blurred line when you reach the amount of time that it has been for these gentlemen sitting in the courtroom. Since it has been 2 years and 4 months, a pretrial detention facility is not designed to house anyone for that length of time. Not only are they not set up and designed to house someone of that time, you also have to take into what the rules state within. We do know on a state level for prisons what those rules and regulations are. However, most of those do not apply to a pre-detention trial facility because everyone within there are presumed innocent. So a lengthy stay there is not usually or typically one that happens And here we have that issue because of the delays. And so, with those lines being blurred, you have to look at what rules and regulations stipulate on each side. And that's exactly what we did. I did come on very fast, rather. I usually give everyone a notice. I was not even able to get in touch with Candy to let her know. The piece of information that I'm able to cover. So, what we do have is obviously the big one that we've heard about in court is the Nelson Mandela rules. So, reading through all of the rules that we have adopted, over 50 of those rules apply to those gentlemen in the courtroom right now. And with over 50 of them applying to each of the gentlemen, also there's the blurred lines between the pretrial detention facility. So what you have for Jeffrey is what they call special housing. And they do special housing when you are on a high profile case, a celebrity, suicide risk, etc. So he met those qualifications when he went through the classification process. And so since he met those rules, there's certain things that you have to abide by when you are within a pretrial detention facility. And what we did was went through to see which of their own rules have been blurred due to how the rules and regulations are set up, and for the state side of it, which ones apply towards a pre-detention facility. And so we do know that over 50 of the Nelson Mandela rules apply. We also have seen that there is a ton of pretrial detention that is questionable. So what you do have is that you cannot stay in solitary confinement for more than 15 days at a time. 15 days is the max. And so I want you guys to keep that number in mind, because we have went on several breaks that have exceeded that time frame, and you have to look at how many months sat before trial started and when jury selection started. And so that was the biggest kicker, was to see what they have in their book, where they're at, and what the state has for rules, and which ones do they have to follow, because both of them are not. They are both being violated. So even if they applied the one where they are in the pretrial detention facility, you still have to go by those rules. And those rules do not change. And so you have to bring the attention to the extraordinary circumstances surrounding the case. And so Jeffrey Williams has been held in a pretrial detention for an unprecedented period of 2 years and 4 months, and there's no end in sight. The timeline of events and conditions of confinement raise serious concern about the defendant's constitutional rights and the appropriateness of continued detention. He was arrested May of 2022. His jury selection did not start until 8 months after the arrest, which was January 2023. His trial commencement was November 2023. That's 18 months after arrest. And now we're in September 2024, 28 months after arrest, and the trial is still ongoing. And so he is still held without bail, solitary confinement due to classification status, 23 hours per day in isolation, 1 hour out of the cell, limited to 1 visit per week. And so what we look at is excessive duration of pretrial detention. The defendant has been held for over 2 years without conviction, far exceeding the typical duration of pretrial detention. This prolonged confinement in a facility not designed for long-term housing raises significant due process concerns. Solitary confinement, the extended use of solitary confinement in a pretrial setting is particularly troubling because, like I said, the United Nations Standard Minimum Rules for the Treatment of Prisoners, the Nelson Mandela Rules, stipulate that solitary confinement should only be used in exceptional cases as a last resort or for as short of a time as possible, but never exceeding 15 consecutive days. The current situation clearly violates these internationally recognized standards. Georgia state regulation, it is my understanding that Georgia state prisoners are prohibited also for holding inmates in solitary confinement for longer than 15 days. It's unclear what legal authority allows a pretrial detention facility to exceed that limit, potentially violating the state regulations and not to mention Nelson Mandela rules, because they have a presumption of innocence. Pretrial detention centers are designed with a presumption of innocence in mind. The current situation blurs the line between pretrial detention and punitive incarceration, which is potentially infringing on the defendant's constitutional rights. The other thing you have is mental and physical health concerns. Prolonged isolation can have severe negative impacts on mental and physical health, potentially compromising the defendant's ability to fully participate in their own defense. According to the Georgia Pretrial Detention Center Rules and Guidelines 11.10, inmate medical and mental health should be addressed 3 times a week, and also states if an inmate is in special housing, quote unquote, there is to be a periodic review of inmates assigned to the special housing. And it states it right there in 13.03. When an inmate is assigned to special housing, his status shall be reviewed at least every 7 days for the first 2 months and at least every 30 days thereafter to determine if return to normal detention is possible. And in this case, it's not because of the status. So you have to look at how long this status has been going on. And then also access to legal resources. The restrictive nature of the defendant's confinement may impede on their ability to fully prepare for trial effectively, raising concerns about his right to a fair trial. And so you have to give these extraordinary circumstances and respectfully request to the court to review the necessity and the legality of the defendant's continued pretrial detention under these conditions. Alternatives such as a release on bail with appropriate conditions, transfer to a less restrictive housing, or expedited trial proceedings should have been considered to address these concerns while ensuring they still had their public safety and integrity to the judicial process. And so while reviewing these things and looking into these things, it's obviously goes to show you that the pre-trial detention facility guidelines are not being adhered to. And not only those aren't being adhered to, you also have all of these Mandela rules that have not been taken into consideration. Yes, they can say, okay, well, due to the circumstances of the case, the defendant should be held with no bond. That is usually okay in the beginning for the first month or two while they're getting the information. And so, with providing the information that you have, and you have to go off of the rules and regulations that they have to follow within that jail, and you see that the lines are very blurred on there. Where I was able to take down over 25 of their rules and regulations that are clearly questionable due to how they're being housed and for the length of time that they have been housed. And then you have to add in all of these other special um, circumstances that are in the case. And those special circumstances are every single witness that you've had up there has been impeached by the state. There has been currently a witness, a lay witness, that was arrested straight from the hospital who I was told allegedly was in the middle of a discharge and has had numerous hospitalizations and just had 2 transfusions before his discharge. And while that's particularly way troubling, that experience in that area, I can touch on firsthand first base knowledge. My daughter has had hospitalizations and blood transfusions due to sickle cell. And she has had the crisis, and what your body goes through during that time and your recovery time after the transfusions are very, very vital and very important. Particularly going to jail and you are post recovery of blood transfusions is a very dangerous situation. And I was told that tonight he has been moved into a medical facility, but that doesn't mitigate that he was held in regular housing in the jail since, I believe, if I'm wrong, correct me, I was given Friday. And if that is wrong, then just correct me in the comments. So you have to look at that as well, because from a medical standpoint, it does state, you have to have straight rest. There has to be elevation. You have to be able to have the heat. You have to be able to have the things that you need coming out of the crisis. And also there are certain monitoring that you have to do when you are post blood transfusions, because you may have what they quote unquote a rejection that can happen when you receive the blood. They do watch you bedside when they are doing the transfusions. However, it can still happen several days leading up to 2 to 3 weeks after the transfusion. Your body can start to go through a rejection process, or you may need another transfusion because you have depleted the blood that they have gave you out. And that was a situation my daughter had. We had to have several bags. And her condition had changed, so we had to go back through that loop. So with that being said, and him being locked up in Rice Street and not afforded those things is a very, very big deal. Not only that, the family has communication on record with the DA's office. And what the father said was it was not even their attorney that they had brought in for him. And so there was a big misunderstanding about the subpoena because it had expired. He was in no way of a threat or eluding the subpoena. He has been in and out of the hospital with a severe sickle cell crisis, along with some transfusions. So they knew where he was. Why couldn't they just serve the subpoena and leave it there if they knew of his whereabouts, where he's at? They knew he was at the hospital. Why couldn't that have just been dropped off? Why would a lay witness go into custody? And he has no pending charges. The charge that he did have, he's already served his time for that. So there's nothing to add to that. What you have to put in mind is what judge signed this arrest warrant and what was marked on the arrest warrant to warrant to be picked up at discharge and put the county at jeopardy with taking a lay witness in with these type of medical conditions that has been clearly in and out of the hospital. So the jeopardy that you are putting onto the county to take custody of him is a very big one because of his medical condition, and he doesn't have charges. And so you have to look at the entire picture. I have to throw into another wrench into it. This investigator that we have been hearing about the entire trial, one that has proven on record, played games with the defense attorney, and which said that she did not until Steele presented the email proof to show that she was incorrect. Gaither is the auntie by marriage of little D. So how can you investigate anything associated? You have a direct family member that is involved. That is definitely a conflict in interest. It is definitely malicious, and it definitely is very noteworthy to bring forth. And we had to document it in the work that we are doing, because that is a very big piece of information that cannot be left out. So there's two little D's, and one of them has a direct relation that is married to his mother's sister. So little D's mama, sister, is Gaither's wife. And so when you put all of those pieces together and you look at the actions that Love and Hilton have had, is insane. It's you also have to throw in the piece that Mrs. Willis's last case was Mondo's. So whatever client privilege, privy information that she received off of that case has directly went into the indictment. And Gaither, having a direct family tie into the trial and does not have a good relationship with little D, has further to have it out or put together whatever information that she's seen fit. So Garlington is the Gaither connection. And so, regardless of which little d it is, it's the same, it's little d that we have that has been talked about in the trial continuously. And not only that, at what point when she was on the stand was she going to let that be known? At what point was the prosecution team going to have the courts aware of that relationship? And at what point was prosecution going to bring to the court that they have a excuse me, they have a lay witness that they have been told is going to plead the fifth to have arrested on a warrant because they had an expired subpoena. There was not a need for an arrest. If they were trying to serve a warrant, you had his whereabouts because you clearly picked him up at the hospital. And so, with that being said, why wouldn't those same rules apply? And so, Gaither has already been on the stand. Yes, she's able to come back. They have kept her subpoena open, but she should come back. There's a lot more that should be questioned. Defense has every right now to go an entire different route. And it's about time that the defense brings up the pre-detention trial rules and regulations, and also all of the Mandela rules that have applied. I have wrote down each of the pretrial detention rules and regulations that have been in question, and also every single one of the Mandela rules. And like I said, over 50 apply to these young men that are in that courtroom right now. They are considered untried prisoners in a prison setting, but they are not there. They are in a pretrial detention center, so they are presumed innocent. Now, should those lengths of confinement be lengthened to the amount that they have been lengthened because of the state's delay? This is not a defense delay. This is a state delay. From when jury selection started to when trial commenced and how long it's been. They had originally said from the beginning it was going to be 6 to 9 months long, and that is what they prepared for. They are double that timeline right now. And for any judge to not think that these lines are not blurred, that is where all of these different rules and guidelines I highlighted and have sent off to share in all of the Mandela rules that take place, because ultimately it does state in there that provisions of health care or any prisoner's mental health is a state responsibility. When you are in custody, it becomes their responsibility. And so you only have to question then, has he been getting the mental health assessments as many times as what the guidelines have been requested? And what was the outcome of all of them? Because they have to share the reports according to 1305 and 1303. And that is pretrial detention. And so I know that Steele and Weinstein and Chart and the rest of the team has been focusing on the bond for this reason, but it clearly shows that the length of time that it's been going on now, you are able to hold someone accountable for it, because it is outside of those guidelines. So you also have to have records. So you have to pay for the transportation. They have to have all of that available. And then also there's also rules for pretrial detention centers. If you are being housed in another facility, they also take that into play. It also states that if you are within those 15 days that you are on confinement, it cannot exceed that. And during those 15, you have to have a minimum of 4 that has to pertain to the same thing that regular population gets, because it's not a punitive punishment. It is a classification, quote unquote, special housing classification, that they should not have to deal with the punitive and take just that 1 hour a day. It states it in the pretrial detention facility guideline. And so that is the reason why I sent off and shared that information, because it is very valuable, because then the judge has to look at it from what the rules say and what the state has said. And during those two, you have to consider one and the other. Both of them shows that it can't happen in a pretrial detention facility the way that it has been. There's a lot of things that has been happening in the trial to add all these extra dynamics, but I think it's particularly important to bring forth this bond with these rules, regulations, and the laws that were made, and argue that point, because it is laid out very specifically for the defense attorneys to be able to follow. And so there should be a huge argument on that, because the bottom line is Whitaker will have a hand in that if she continues to rule no bond for the length of time that it has been. What we have seen is the state is not ready. They are unprepared. They're late. They don't meet deadlines, and they have not done what the court has asked when the court has given orders. There are several times everyone can go back that they have not delivered what they were ordered to deliver. And that is because there's an issue. Not only with the issue is there's a huger, not huger because that's not a word, a way bigger issue, the RICO. They don't have the ingredients that they need for a RICO. And the way that Love had argued it 2 weeks ago clearly lets you know their office is not familiar with RICO. And RICO is very complex. You cannot add anything before or after what is in that indictment. You cannot go outside of that indictment. You can't even produce evidence outside of what is within that indictment, because the grand jury only allowed for whatever was within that original indictment. So what you're seeing is obviously some discovery that's being had all these 2.5 years later come in, that the judge should take the RICO guidelines and she shouldn't let it in for not only the RICO guidelines, but also discovery is due 10 days before trial. Now, if she wanted to make some exceptions to that, RICO is very specific. And unfortunately, they don't have all the ingredients because these are typically held for large organizations where they have all of these overacts that have to either be found guilty or not guilty. And what you have here are charges that have already been charged and committed and time already done on all of these acts, and they are all over 5 years. So there's nothing in those overacts that any of these jurors can find guilty or not guilty. They can only simply answer yes or no, and it holds no weight. They also have to list out every single one that they have listed on the indictment. And each defendant has their own verdict form. So when Love stood up and said the jury only needs to find one guilty of that charge and they're all guilty, that is not how RICO works. RICO does not work that way. They can read the case law forward and backward on it, and that's not how it works. You have to have a unanimous of the exact same overacts, and they have to be able to be applicable. And none of them are applicable. You have 191 and 190 that are not applicable. And then you have to go with the other part of it in furtherance of the corruption and organization. That whole part still has to be proven. You can't add overacts onto it. You cannot add evidence in. You strictly have to stick to what is in the indictment. And so, what I want to see is the defense to argue that point a lot more, because then they will see that the ingredients that you have to have, the 3 ingredients, they don't even have. And so that should also take place. Also, I would bring in the same indictment that was on the YFN that was eligible for bond. That is a big comparison. And everyone that they said was so big, bad, and guilty were able to get pleas and out and no longer a threat, as long as they did what they were told to do. But what we seen was a total mess along the way, and we seen that they have been violated. These witnesses have been. Not only the witnesses, we are arresting lay witnesses. This is not the first lay witness that's had a warrant and arrested. Mrs. Bennett was one of them as well. And it came out through her testimony that she was actually being sexually harassed by a DA investigator. And that was swept under so neatly. And not only was that swept under the rug, the judge should have been concerned with that and take that into consideration. Not only take that into consideration, but there is a lot of violations that have occurred, even with Diamante Kendrick's his being arrested and taken out of the Sally Port after he had invoked, which we already know that they don't have that right. And so the judge had the initial ruling to that correct. And then Love got to keep arguing it, and then it was changed. And so you have to look at, how are they continuously able to get away with it? Well, now Whitaker is there. Now Whitaker has enough time on that bench now to be able to see what they have, what they don't have. She's able to see what they have not complied with, what they have been late on, what they have been ordered to do, and what they have not complied with. And in what situation have you ever seen a subpoena be exhausted because of the time and because they weren't able to get it served in the manner that they wanted it served? They just said, okay, we'll arrest you. Even from the hospital, and taking on that medical liability for a lay witness that you know is not in cooperation with you because your office has been told. And so you have to look at the entire dynamic and what is the post, what judge, and was it Whitaker that had agreed and signed off for a lay witness to be arrested out straight from the hospital? A lay witness to be able to take into custody that you know is not going to testify. You have been told that he is not going to testify. And it's obviously going to come out, whatever attorney that they said came in there with them is going to be a very interesting dynamic, because dad has came out and said that wasn't one that we caught. Our attorney said, I haven't been retained, so I can't serve him. The doctor's office said, I can't get involved with that. So then you have him at the hospital getting his transfusions again. They covered it in court. He was sick. They knew where he was. But why wasn't it acceptable just to serve the subpoena? So if you could not find him, and you are stating you went through these channels to get him served and were unable to serve him, well, you found out and you knew he was in the hospital, why wasn't it good enough to serve? Why did the arrest have to take place? He's not going to get what he needs. And who monitored him for 24 to 48 hours post transfusion? Because that's what you have to do. I've been through it. I've been through it with my daughter. And you have to keep a close eye, and there's certain things that you have to do. So if Love stated that they need an arrest warrant, he's eluding the subpoena, he's out of the hospital now, but that's where he's picked up from. I mean, the reports does state where you're arrested at. And if it is the address of the hospital, clearly the family has a big fight, because they have already communicated to the DA's office that he will not be testifying. That what he was named and what he's talked about in this trial, he has already served his time. He's already done. He owes them nothing. He is not on the indictment. He has no charges. There's nothing else that can be done to this young man. He's done his time. Unfortunately, his health is not well. So you would rather take control of him and put him in jail and take on this medical liability instead for a lay witness, not someone with a warrant that you've been trying to catch up with that is named on the indictment, for a lay witness. I mean, there has to be the judge that signed off on that warrant has to be questioned, because are we going to see the exact same thing that we seen when it was in Glanville's court and you had Detective um, the Quinn that wrote the warrant up for the judge to sign, and defense went through that and seen that those circumstances were exaggerated. Well, there is rules and laws that apply to that, that when you do exaggerate those warrants on what happens with that. And that was proven in court. So, do we have another one of those situations where the warrant has been exaggerated again to have it signed? And what judge would sign a lay witness to be arrested out of the hospital on discharge, when he has said that he will plead the fifth? He's done his time. He's a lay witness. He doesn't have to. And they have to accept that answer. There's nothing that they can do um, in regards to that. There's nothing that they can do. This is not a Woody situation where Woody had forced immunity where he had to, and had charges that were pending that he found out later were dropped. Regardless of the situation, little D is not your star witness. He is a witness that you wanted called, but however, there's no agreement. There's no plea. He owes you nothing, but you owed him a warrant because you couldn't serve a subpoena that no longer was valid because of how long of the time that passed. Well, that goes to show the judge the timeline. So it's going to be a very interesting day tomorrow, because there's several things to have to argue out, but the defense clearly needs to say that this is now a pattern. And why they can say it's a pattern is because look at what's happened with all the other warrants. They have been exaggerated or they weren't legal. And they had to, there's litigation on the side going on about Jeffrey's jewelry in his search because it wasn't authorized correctly. And so you have to put all of these things into the melting pot. Now you got to add in Gaither has a direct, that's her nephew. She's got a nephew. Little D is her nephew. When you're married, it's legal then. That is your nephew. So there's a conflict of interest there. Miss Willis's last case as a defense attorney was Mondo, who has come out publicly that says he is a YSL founder. But they have changed that label to fit their belief within the courtroom. All of these things take place. You also have another one that says was a founder who was under a plea deal. He's hit the stand. So the judge has to take these things and wait and look at the bigger picture, because what we've seen with Woody and the DAs is they have played undercover investigator, and your firsthand information you thought was so good from Gaither and Dennis, with Gaither and Thorpe, when Gaither had an ulterior motive to begin with. And so imagine that family dynamic. And then the father said she used to ignore 911 calls and then got a promotion. Now, those are his allegations. I don't know the truth with that. I know the truth with the letters that we were able to do and the different things that we found with the pretrial detention and all of the Mandela rules and what the state law is. And Georgia is one of the ones that has actually been litigated at a higher level. And they recently just ruled. So they have to equal in that equation now. So circumstances have changed. And it would be smart for the defense to use all three dynamics because that weight then goes to the judge. And so if it's heard on a higher level, God forbid, it has the ones that would be held responsible to think that through all of their delays and extensions that a pretrial detention facility is set up to sit in for years. They're going on year 3. These months are flying by really fast, and 3 years will be approaching before we know it. 3 years. 3 years. And we have not, Rico is still in Porto, still hasn't showed up. Like I said, you can tell that the state is very unfamiliar with RICO. The case law on RICO is very specific due to all of it is very hard. I know probably in their mind, not having the experience of RICO, and that is a newer thing for Fulton, is throwing out all of these RICOs. The ingredients that it takes to have to prove different, you cannot take all these old acts and throw them at the wall. And what you're seeing is from the original indictment, they are steering out of that and adding more stuff in. And if you consider it a RICO and you are charged with a RICO, you cannot. You have to only stick to what is in there on what that grand jury signed off on. And if you don't, there's a remedy that states right in the case law on what happens from there. You don't have a RICO. You cannot. So I know Love had talked about adding in charges that were post and pre-indictment. You cannot do that. The grand jury did not indict that. You cannot go outside of what that grand jury indicted. And we are seeing the state bring in all these different dynamics that are late that the defense is just finding out about. And I just want them to argue it a little harder to say that they are outside of the RICO guidelines. You may, however, be able to do that if you would have brought it one-on-one. You can throw whatever you want to in at that point. But for a RICO, you cannot, according to law. It doesn't matter which way she tries. And when she argued it, they just brought it up again on Friday when she said, I'm still waiting on case law from that. Well, they're probably having a hard time to find something to support that because RICO is very specific and there's only a few cases that give you the exact specifics. But the very thing that she is trying right now is covered in 3 different cases, fact specific. And it also has what an appeal judge said and what errors the trial judge made. And it is the same errors we are seeing right now. And that is what happens is when it's easier for you as the district attorney's office to throw all these charges at them and put it on a RICO, but your people must know what a RICO is and what ingredients you have to stay within. It's not like the case, the state charged you for something, you go to court, they find out 12 more things, they add more charges. Sorry, in a RICO, you are not allowed to do that. So they have a lot of arguments to be made and a lot of push that is higher at a higher level. And it's like Whitaker was trying to get an understanding of love and was trying to get an understanding of what Steele was saying. And she knew a little bit, but she knew that it couldn't be outside of this indictment. But where she's making her mistakes as the trial judge is she's allowing certain things to come in that aren't within that indictment. And that is where she's messed up at. And it's already on record and it's already rulings that have been made. So you have your prosecution team taking out ingredients. And you have, on the other hand, a trial judge that is allowing certain things in that they may be arguing, oh, well, this is character, or we never heard about this before. If you didn't hear about it and it's not in the indictment, it does not come in. And defense needs to push that a lot harder. Because you cannot get out of those RICO clauses, those overt acts, and trying to bring in other pieces of discovery that the grand jury did not indict. And every single defendant has to have their own verdict form. And for Love's understanding to be only found guilty of one, that is not correct. And that is not correct by law for RICO. So she's missing the whole ins and outs and substance of RICO that is going to eat her alive, because she is pushing these things as if it is just a regular state case, no RICO. So it very well looks like they were looking at, they can charge more at the same time, but didn't know the strict guidelines that RICO operates under. And so it clearly gives you an inside look of her depth into the legality portion of RICO and what all the ingredients are, when she says that the state does not have to list 191 overacts. You definitely do. Because what one person did, they cannot charge to the other one. Every single defendant has their own verdict form. And if they are not in unison, you do not have the Corrupt Organization Act of what you can apply with the RICO. And those are facts. And then how many lines have been crossed? How many of these witnesses do you think are going to come back on a hardship with the state for harassment, for pressure, for corruption, for what proof that they have that their dealings through the case is the exact question? Because what they have done with this lay witness now, yet another one, we're not surprised of the act, because you have to remember she did something very similar to this with an autistic boy that had a whole bunch of issues that was ordered to the jail. Even though he had a charge, his case was a little bit different, but there was what was similar in that case was the medical. And Love did everything she could to stand him upright for trial. Well, he's deceased now. And so there's that. There has already been too many in that jail that has not come out. And here we are for a lay witness subjecting another one. Why was he just moved tonight to a medical facility? Why wasn't that done immediately when he was apprehended, if that is what you wanted to do? But why couldn't he just be served the subpoena? Why did he have to get arrested? Is it because you were told that he was not going to testify and he was pleading the fifth? Is this another tactic or measure to use? Because none of this stuff is going to come favorable. The way Love is presenting herself to the world, like there is no core inside of her. If it's not going to work in their favor, they're going to make sure that they do what they need to do to make sure that it works in their favor. But what they don't understand is all of this has hit the record. All of this is on the record. Why would you even put forth any more resources into this case when you know this case on appeal is gone and potentially gone at verdict? And not even to mention, you don't have the ingredients for the RICO. You can't use all these old individual acts of individuals that know each other, that are friends with each other, that have already served those times on the crime, and put a case bigger than what it is to meet a narrative. That is where it falls apart, because the jury is not going to be able to find any of those acts guilty or not guilty because they don't apply. They're outside of the time frame. And you have to have clear proof that it's done in furtherance of. There has to be proof in furtherance of. So that big pressure point on Woody and Monktunk about what was discussed, she was questioning and coming back to question in a way to try to make it as if it was premeditated, because that's where she would have used in furtherance of. And they're saying that is not the issue. We went there because we knew Jeffrey was getting ready to hit the road for a show. We knew he was leaving. That's not anywhere near what you would see on any of these RICOs. When you read RICOs and you actually read into them, you will see that they have to be fact specific, and it has to be all within, and the proving in furtherance of, it is hard for them just to prove the basis. They're still trying to figure out foundation. So how can you figure out or try to pin in furtherance of? That is why you're hearing theory and belief. So my focus over this weekend was to go through all of the rules and regulations of the state prison rules and the Georgia pretrial detention facility rules and guidelines. And I had to write down every single one that has applied to Mr. Williams and his co-defendants. And I literally have 1, 2, 3, 4, 5, 6 pages front and back. Not only that, we have letters that have went out to, and I'll give you the, let me give you, we have letters that went out to the judge, to President Biden, former President Trump, Attorney General Garland, Congressman Jim Jordan, Governor Brian Kemp, Attorney General Chris Carr, and also the Justice of the Supreme Court, Department of Justice, State Bar of Georgia, also Department of Justice Office of Professional Responsibility, and we have the chairman. And obviously, it is to cover all of the things that we have been seeing from day one. And at some point, there has to be a huge advocacy for all of these things being crossed. And what was it that the other two DAs that were assigned to the case have physically left that office during the middle of this case? What changed for them in this trial that changed their employment? And why was it so deep that their employment changed midday? For the woman, Mrs. Elizabeth, that was one of the leading prosecutors, she didn't return after the morning. So she did her morning in court and did not return back to that office. So what is it? For two of them, and then you see these two come in, and I think that they thought, oh, we got this in the bag. We're going to do it our way. But the information that you've come from, you have two main sources. You got your boss, that's the DA, that dealt with who they said on record, and he's put it out there in social media everywhere. He's a founder. You have your other one, Winfrey, who was stating was the founder. And is he in relation of connection of the court reporter with the same last name? Because to me, they favor. My son always tells me I'm a DNA expert. I can look at characteristics and tell you I was always 100 for 100 on Maury. Proudly. I don't know, it's because I studied DNA for so long. I don't know what it is, but I just learned that there's certain characteristics that kids can only get from a father and certain characteristics that you can only get from your mother. And so I would always look at a child and say, nope, yep. And I'm always right. I have never been wrong in that area, which is crazy. But here I'm hoping that I am. There is of no relation, but it just shows you how many conflicts of interest that are at hand with this case. You got a biased judge that had to be recused. You got the main investigator that has a direct relation to one of the ones that you hear all through this entire case. And then you have the district attorney that brought all these charges about that had firsthand client privilege of YSL through her client that she represented in court as her last defense. So it tells you a lot of things. It tells you a lot of things. What does it point to? If Judge Whitaker doesn't want to talk about those things or put any of those things up, um, file a whole bunch of motions, file these motions. If they are denied, get a certificate of review, send them up. It's time to send them up because the playing on this level, and for defense really needs to crack down on all these missed deadlines that the state has missed at this point. It's detrimental at this point. They have been ordered to do so many things and they have not complied. They are late. They're unprepared. They don't have their information together. You can't tell me they didn't know Gaither's connection. What did Gaither say when she was on there? She sees Miss Love every day when she worked in the office. So you're going to tell me that never came out? Miss Love, I know you're prosecuting this case, but I want to tell you that Little D's my nephew. That I was doing an investigation on my nephew and his friends. And somehow they ended up with Woody. Probably one of the worst ones that they could probably end up with, Mr. Spinner himself. As Weinstein says, a good bullshit artist. I don't know how any of this can be anywhere near just um, pillow talking. You got your wife. What did your sister say? Call your sister, maybe get this information. Where's he at tonight? I don't know. Find it out. And I definitely would look into if she was a 911 operator at any point in time, if she did have missed calls and hung up on people. As a county, they should be, when that hits the stand, that information hits the stand, I would definitely be really concerned and have to throw a whole bunch of flags if they don't find anything wrong with that. They need to look into that because that's literally a charge. And why wouldn't it be a charge for conflict of interest? She took on that case and was investigating it for a long time, even with that conflict of interest. And because Mrs. Willis had a conflict of interest, she could not participate in this case. But why have we seen motions that were from her in support of Love when they were asked to have her excused in what she should have been? So you have to look at all of these things. And now a lay witness that they thought it would be more appropriate to take on the expenses and his condition and take that liability on for a lay witness that you can't do nothing to. And it's really, really sad because I wasn't going to put it out today, but I made a video for y'all. And I'm going to probably play it tomorrow because I just want to edit one more thing. And what it is called is The Real Jeffrey They Don't Want You to See. And it's literally from where he started to all of the things that he has accomplished and how they want you to put him in your mind is that he's on Cleveland Avenue somewhere with a whole bunch of guns on the corner, which the projects he was from in that area has been demolished. They have torn them all down. Does the jury know that that place right there doesn't even exist? Do they know that it's demolished and has been for years? Do they know that where he's been and all the cities that he's been and out of country, and all of these dates do not even align. I have footage of him that shows his professional team the entire way and what they've done and the type of props that they use for videos and all of that. It debunks everything. I have videos of him sitting down and doing fashion edits for album covers with people in London that have been working with him for years. Photo shoots, magazine shoots, clothing line, having to go through that. So I did an entire video from young on up, the Jeffrey Williams they don't want you to see. Because clearly his old videos and pictures that they have of him literally do not even align with what they had. And it clearly shows when he's tried to help each one of his childhood friends to get them out of the situation. Also, I included the part with Little Baby. He paid him to stay out of the street and to commit himself into the studio. Now, if you're in the street and you're supposed to be running the streets as the DA is going to portray, and they have been trying to portray that narrative, why would you pay another person to stay out of the street? Make it make sense. You have label owners that have come forward for him, but not only that, the fashion designers have as well. And I have them on the video. Um, it shows his character. It shows him throughout the day of what he did with all of his professional people that he dealt with day in, day out, long before 2015, 2014, 2013. So the defense has to put foot on necks now. There's enough that has occurred. They should not, they've had way too many conflicts of interest that have intruded this case. And they don't even have the substance of RICO because it's several layers of RICO. It is a very, very detailed oriented laws that you have to abide by on RICO. It's not like a regular state case as what they are used to, and that is how they're trying to treat it. So the judge needs to up her knowledge because she is not a RICO expert because they don't have those type of trials that she would have been used to. Also, why it's a conflict of interest for Whitaker, because Whitaker, before she took her place as judge, was the deputy district attorney and was in the office at the same time that they have been in the office with the years. So why was that conflict of interest not used? That was still a coworker. That is still a coworker. Go with him. Go. So if the charges wanted to be brought with Fonnie having her last one with Mondo, who is a founder, put herself out there, conflict of interest. Whitaker, you worked with Love. You worked with Hilton. You were there during the same years that Whitaker was a DA. It has how many years you have been with the counties. It's right online. That is a conflict of interest. They were once your coworkers. At minimum, if you were going to bring this charge, your neighboring county should have delivered it, because they all have that rule where they can now do that with the neighboring counties. So why did that not happen here? Why did they automatically take it? And why on the original indictment, Glanville's name is handwritten on that paperwork, and it never went through the wheel of assignment? So those are questions to be had. So I just want to know what you guys think on all of these different dynamics that we talked about just right now, and some of the things that I brought forward with all of the letters that have all went out. So I told you guys I could share more once they were all out and delivered, and they all have went out, and they have made it to all of their destinations with confirmation. So with that being said, what do you guys think about all of these conflicts of interest? Do you think that that needs to be pushed way harder because there is another judge in seat and they haven't been expressed to this magnitude? Because most of the information that has been coming out as the trial has been progressing over a slow snail pace. But we have seen all of these conflicts of interest have a direct impact to the case. And that's one thing that can be proven. Gaither was the main investigator on this case that was getting them the material information that they wanted, quote unquote. That's what they had Woody for. And Woody was playing a spinning game because he was trying to spin his way out, but they were spinning each other continuously. So how do you think that back end is going to work, putting it all out on the table? Because another jurisdiction will have to look at all those conflicts of interest, and then you have to look at how many months, which was, we're at 2 years and 4 months right now. Whitaker has been in for 3. So 2 years and 1 month under Glanville that has been recused, and they have transcripts from ex partes to display from June 7th, he was biased. June 10th confirmed it. And they have what his responses are to show you had a biased judge. Would that be Judge's Krause ruling? No. If she had the June 7th transcript, because that's where the personal feelings came in at, it would not be the same ruling as in appropriate. So there's a lot of things that are happening that have to be brought out on the table, because there's way too many conflicts of interest that has been hitting the scene, our main people that have taken this case. Beautiful One says, yes, Whitaker admitted the other day that she was going them handle their own case. Believe me, the defense ain't missing nothing Whitaker is doing. I don't know. I mean, I think she's already done enough of it that it's being called out so much as now she's erring on the side of caution. I don't think that was meant to have some substantial weight because she has been doing it. And the things that have been allowed in has been insane, which makes no sense to anybody. And you wonder why the nation is upset and they call her Glanville 2.0, Glanville 3.0, is because you have to look at the entire picture. Glanville started doing the exact same thing, finishing their sentences, asking, are you giving it for this, but you can't for this, but you can for this. Glanville was doing the exact same thing, and it kept getting worse and worse, and then he couldn't hide it no more. And then he just went all out his way. So, beautiful one, that's a good, it says yes. And why didn't Judge Krause get the June 7th ex parte? It should have been announced. If you were trying to do the right thing and you had nothing to hide and your hands were not dirty from the jump, June 7th, if you go back to June 10th, and the defense said, how do we know if there weren't other ex partes? And Love was shaking her head. And when it was her turn to talk, she said there was none. It's just way too many things that are surprises that are being done and the situation that is coming into place on how they're dealing with it. And nobody, state or judge, is not seeing conflict of interests, several of them, and a pattern here. So who's responsible? Could Whitaker put this off on Glanville for allowing it in? Or does Whitaker take the hit for taking it and inheriting it all and not going through every single piece? As she stated, she's not going backwards. Well, you can't go forward unless you know what you're doing, what was done behind you. There's no physical way that you're not able. You cannot put an entire case together, rule on things, if you don't know what prior arguments have been and why certain pieces of information that are just now being litigated right now has significance, importance, because you missed the first arguments on those in the behind work with Glanville. And whatever brief you had about this case, I'm pretty sure with the complexity of this case and how long this case has been going on, you had to brief with him. And clearly, whatever it was, or if you didn't brief with them and you're trying to go off of transcripts, because she is not a video person, she is a transcript person. And that court reporter, I don't know why her name is slipping my mind right now, but I can see her face. I can't even think of her name now. On how you can solely rely on that and you're not reading exactly from the very, very start because all of those transcripts are not ready. So the important parts that we're seeing being litigated right now have been raised a year and a half ago, a year ago. It is her job and her duty as a referee to be more than briefed if you are going to be litigating and ruling and making rulings on what is being litigated right now, but you have missed the entire argument or the evidence that was trying to be used that was lack thereof to get that ruling. How many of you guys remember when Adams addressed the court and said that Madam DA was fact specific, and it was about the video where she says, Your Honor, nothing else can be heard. And then all these other statements are in the background that Adams and Steele were able to go down to say what was said. And then she says, Well, that's not what I heard. I missed that. How can you miss that? They're speaking in tandem. And she was allowed to be able to readdress the court based off of that. And so you have to look at that. You cannot parachute in, as she said, and be able to rule on things correctly that are being litigated right now because you missed A, B, and C. And so for her not to have the significant reason and meaning and why the defense is in a frustrated state, they asked for these things a year and a half ago. But you want to be brand new and say, well, that doesn't, apply. I was not here then. Well, you are now, and you've been on the bench long enough to have familiarized yourself with the previous months. There is not much of the day-to-day court to go through because there was extensive breaks and several weeks out at a time. Not to mention, you have a whole 10-month gap from arrest to when jury selection started. And then you got to add on almost another additional 11 months. It was 10 months and some change before the trial even started. So if she's looking at the amount of time to actually go through the information, the delays and the breaks really save her to where the video content that she would actually have to really review is probably no more than 48 hours of court time that she could actually get done in one weekend in the privacy of her own home. And if lives of these gentlemen don't mean that much, and that shows by the ruling that clearly states your position. There's no way you can take on a case to this magnitude and think that your rulings going forward and you have missed arguments, litigation, and lack of evidence prior to, and things that have been allowed in that shouldn't have been allowed in. And then you guys don't even have the fact specifics of a RICO and don't even know the layers to it and how to successfully roll out a RICO. You don't have the material for it, regardless of what you try to do. You don't have the ingredients. You can't make the ingredients. It's not there. That is why you've seen RICOs be used in mob life and all of those things, because they have crimes that were clear that it was in a movement in tandem together, and you have all of the evidence together on that, and then you have the acts, and then you have the overacts. They don't even have one of them. They threw a whole bunch of everybody that they thought were connected and took their criminal history as a solo individual and has tried to wrap that into overacts. And these charges in time, that the ones that did have them, they're already done or still in the middle of serving. Oh, yeah. Beautiful one. Thank you. It's Miss Weaver. I did know that, but I don't know why her name just slipped. I was just picturing her in my mind of a picture I seen of her and Woody in the hallway at court. So you have to look at the bigger picture. You have to look at the history. You have to look at everything that they have. And the defense has way more than enough substance to collaborate it all. And I would just be spewing out motions at this point, for all of the mistakes that have been occurring, especially this past 2 weeks. They have been really critical. Um, Friday was a wasted day. They weren't ready to go again. They had juror issue the day before. They weren't ready. Couldn't argue Harvey's motion. I mean, why try to argue it? He's right. And he even said that, just say, I'm right. And I laughed at that part because he is right. You read it, it applies. There is so much nested hearsay buried into this that this could not survive no reasonable doubt. And can you imagine what the jurors are thinking? Almost all their important witnesses that have been up there on that stand that they wanted to get some type of credibility from have all been charged with Donovan Thomas's, and it's all been dropped for them, and now you have a new set that has that same charges. Nobody's eyebrows went up, and they were all dangerous until they signed. I've never seen a factual statement coming from a supposed quote unquote witness that didn't write the facts, that didn't write the questions, didn't write the answers, didn't write any of the information. It was already provided. That is the biggest red flag. That is the biggest red flag. And for the attorney to be put on the stand for a day and a half, we're at the part in this world where if you represent your client and there is a potential that you will be put on the stand for your client's credibility, or really kind of going into client conversation, because Love was asking, did your client understand this when you guys met? That's not for you to know. And so it's just really interesting to see. And then when Hilton said, well, we don't want to get the ME when it came to Rodelius Ryan. Why would you get the ME? He's already serving that sentence, and that sentence is that case is in appeals. And when Judge Whitaker said, I mean, for what purpose? What would you need it for? And they just looked, because they're trying to throw whatever they can at the wall. And it's really sad when you guys see the video that I put together and you see the years throughout Jeffrey. He got a pure heart, pure, tried to help everyone, bought his siblings all home, a vehicle, stabilized his parents, stabilized everyone around him, and tried to get his very childhood friends out of poverty. So it's going to be really interested. If I heard that right, Ashley Merchant is representing Mr. Sprinkles. I don't know if I heard that correctly or if I came in. I know they said, I know she is representing, I believe they said it was Mr. Sprinkles. Oh, beautiful one. Just put a comment on there. Beautiful one. Was that with, is she representing Mr. Sprinkles? See, I wasn't sure if it was or not, but that goes to further show you exactly where they're at on it and what is being done. But Steele has every right to put Glanville on the stand, has every right, according to law, to put Mrs. Love on the stand and Hilton on the stand because on numerous occasions they have interjected themselves through direct that there's no way to not question them, and then also the ex partes, and then also they are a witness for his contempt. You can't get around that. And I know that they had their brief with the Supreme Court. That was Friday as well. So Thursday or Friday, I believe it was Friday. That was a big deal because it's going to be really interesting to see how they respond with all of the information that was put into that brief. Yes, beautiful one. I did hear when Whitaker said she did not want to bring another attorney to the stand because that didn't work out good for her the last time. I did, and I heard, well, did you hear Love's response? What did she say? Well, I didn't want to in the first place. Then whose idea was it? Because she's the one that stood up when all of that happened and says, well, we'll put a subpoena. So was it Hilton's idea or was it Atkins' idea? You are the one that announced it during your questioning. So whose idea was it? And when she was taking forever to respond and she had to text first, who are you texting? And it seems like when there's no explanation, her voice is really low. And then when she gets all excited is because she's upset. So then she becomes just loud and wrong. It says Duke is Merchant's client, not sure of his real name. That's what Pamela says. See, I'm not sure. I don't know why I thought it was Mr. Sprinkles. Um, I don't know. It was just the responses that we heard coming from Love all of last week. From Sledge to Wright to um, who they called as an expert for the Infinity. His testimony was demolished. I mean, defense demolished that. So it was clear he was trying to go off of what was provided to him. And he said, but then he was not able to recognize it. But then when Atkins was questioning him, he was trying to say it. But when Adams got up there, Adams took his time and really discredited every single thing that he had just said. And there was nothing he could do about it because the evidence is right there in front of you. Nobody can make out that vehicle. So You can't change what the evidence is with facts or facts for belief and theory. Those things don't go hand in hand. But what people don't know and what we're trying to get people to understand that this has been a long wait on trying to get him. It has been almost a family history of issues between law enforcement, and it started with his father because of a affair his mom had. And you hear Jeffrey on his tiny desk address it when he's performing. And so the vendetta started then. And then it started targeting all of the children. And you'll see that and hear more of that when Jeffries wraps up. Because there's other cases that are going on that they were gone at the exact same time. So this is not just a one case or two. They wanted him. They've been wanting him. They wanted his father. They wanted his brother. They wanted the grandchildren. They have a story to tell, and it is deep. And you're literally just seeing one side of it unfold through Jeffrey's case, but it's unraveling all the other unjust, undue processes that has been taking place. And it's really, really sick. And it lets you know that, we even showed you not only the connection that Miss Willis had with Mondo representing him and giving firsthand information and turning around and utilizing that information that was privileged from him. But you also had the direct connection that was her partner at some point that also worked in the courthouse, but also was of a DJ by night that did work in a festival with TIG. There's so many back end connections that courthouse was never fit for the case. It should have automatically went to an outside county, but it's not like there was nothing new that occurred. They pulled a cold case with a direct motive, and that was Mrs. Willis's choice. That was her first thing that she said she wanted to do when she came into office. So her first precedence as taking seat, you have her in an interview stating this, is to make sure justice was got for a head blood gang member. That was her priority. That is where she put extra resources to ensure that she was able to uphold the promise that she gave Mr. Thomas's mother. And I don't know about you guys or how your guys' neighborhoods work or what it was, but you have all types of gangs around all inner city. And most, when you're in poverty, you see those things all the time, every day, where they're first nature to you. So how they're trying to implicate it and put them together is from childhood up to fit the narrative that they have thrown together to make it work for her. It's just constant information, belief, information, belief. This is our information, this is our belief. And you can't. You can't. It doesn't work that way. Big homie Slick says, I'm glad I caught you. I wanted to ask you, what was that you up there asking for Rule 22? No, sir. I will not. No, sir. Are you talking about the red and yellow? Because if you are, if I could sucker punch you right now, I about will. That might be a threat, big homie Slick, or it might just be a promise. You are wrong for that. No, sir. I will not get a Rule 22. I will not ask for a Rule 22. I am not interested in a Rule 22. We are 2 years and 4 months in. This trial has been going on. I am only interested to be the extension of the help that I have been providing and the political side of that. Slick, I don't even know if I can forgive you for that. Like, you are past just wrong. Hi, Wild Spirit. Hi, Politicking with Mel. Slick, that is just wrong. I don't even know if D's still here, but if D is still in here, he just better stay in his corner and not come out with your comment. Oh my gosh. You did not. And I hope you did not put that out there anywhere, because I literally will have to go a whole nother direction on this right now. Wild Spirit out of order is not even the word. He needs to be rebuked and admonished, is what I'm going to ask. No, guys, I have told you guys time and time again, I am not interested in streaming the trial. I am not interested on doing that because I'm covering a whole different side of it. Mel, please do. Mel, like, handle that, Mel. Handle that, like, ASAP. Because he knows he's just wrong for that. I know there was so much going on. A lot of people were saying stuff on that. I did not come on Friday. As I told you guys, I had a medical situation and then I had to work on this other stuff. Yes, Slick, rebuke and admonished. Go to your corner. You are in time out officially. I don't have any moderators. I do got to get some moderators because I do have a lot of people that do come on and I can see them on the back end and not the front end where they're on the comments. So I am gonna, if any of you guys are interested in modding, I do need a few moderators as we're making some adjustments to the channel. And it's going to be hard for me to be able to review and engage in the chat with some of the guests that's coming on and when we do read the letters. He said, not the rebuke. Hey, Keys Mobile. Yeah, so it's crazy to really see what we're seeing every single day. And I just want to know how Love is going to present this situation with little D as a lay witness. Des said, let me write down Des. I'm going to drop, okay, Des. I got politicking with Mel. Okay. I'm gonna put my email down if you guys can send a email to there because I would need your email address to add you on the back end to be able to mod. Let me just make sure that that is the correct one. Okay, so far I got Des down and politicking with Mel. I got YouTube down. Any of you guys want a mod, just send it to the email and I can get you set up on the back end. It will be a tremendous help so that way the chat can be engaged when we're doing our interviews with our special guests and when we deliver. We are coming up in a short time for us to be able to present our speech. And so I've been working on that. I've been really excited for that, just getting all the material. But this weekend has really been about all of the Big Homie Slick. Oh my God, I can't even say what Slick. Oh my God, you're killing me. You're killing me. You're killing me. And then you said, was that me for Rule 22 when you know good and well, hell, I have told you time and time again, or have told everyone, I will not do a Rule 22. I am not streaming the trial. I am streaming the information that is wrong about the trial and putting what it is. So that way it helps in the fight. Mel 86K, Slick, as soon as you get that wrench, please. Oh my gosh, could you imagine? Mel, you'd be putting them on a timeout like every day. I don't know. Where's D at? D usually it will come to get Slick. What did you guys, I mean, what do you guys think about all the Rule 22s that are going in? Do you feel like the more media, the better? Or do you feel that it's going to cause an issue with the judge with so many asking? She said they are PIC. Slick is lucky because I think I probably would have sucker punched him today behind that. So there's a lot of Rule 22 requests right now, and I know that they have the streams that are happening. I know there's a lot of coverage. Um, I have not changed my stance from it. Pamela says people are definitely starting to see what is happening with this trial. Pamela, as I said on the last live, forever grateful for, the extra eyes, but use them for the fight and not for the stream, is what I say. Because you have to think of the young men that are in there that are fighting for their lives. And you have to think of how much that they are being turned every which way but loose onto what their belief is for the state. And you're seeing that they have the power to just throw you in there and lock you away until they feel that you're going to do what they want you to do, but you have not seen justice come into place or anything that is close to it. All we're seeing are different setups. And so I'm not interested to view because you guys watch the trial every single day. Um, and that's not what I do. I'm not a trial streamer. I'm not interested in that part. I'm interested in fighting in the appropriate places to be able to get the change. And I've done it successfully. Um, it's a lot of work and it's a lot of research, and you got to take a lot from it. And honestly, I wouldn't be able to get the information that I get if I don't watch the trial. And if I do not hear what the defense has and I do not hear what the state has, I wouldn't be able to put all the stuff together. D, your boy is wilding. Glad you're back or wherever you just came from, but there's a new requirement for you. If Slick is in the chat, you got to stay in the chat while he's in because he needs somebody to put him in check. So that is my reasoning behind. I never had an interest in streaming the trial. It is streamed on so many different platforms and being covered a different way. I think it's important to give the education on it and why they can't do certain things and what you're seeing and why it's wrong and where does it say it's wrong, and showing you guys the different documents that we've shown is to give you guys the other side of it. Because anybody can stream it, but then not have the fight in the appropriate places to make a change, to change these gentlemen's situation. Wild Spirit says, D, she needs you to grab Slick by the ears out the chat. No. Wild Spirit, I didn't. And so it just gives a different, and it's not to take away. I have to go on different platforms to be able to catch different things that have been streamed or whatever else. But my interest is a whole different interest, and it's on the policy, the law side, where it's blurred, where it has to be fought, and what it says. There's so many rules and regulations that are held to pretrial detention facilities that what is happening right now and using your authority to lock up lay witnesses that you feel you weren't able to deliver a new subpoena because the other ones expired. That is poor preparation on the state's behalf. Because for one, that is your witness that you're calling. If your subpoenas are getting ready to expire, that's your job to handle that before it's already expired. So having all of these extra things put into place, just like they did Miss Bennett. Miss Bennett didn't jump when they said jump. There has been others that have lost their job because they were demanded to come there. The judge needs to be made aware of all of these things because that judge was not present. And so that's what I say about kicking out all these different motions. It's like, look, you have to explain to the judge as a defense attorney, you have to say, look, I understand you weren't here. You're not interested to go backwards. But however, this piece of information is tying to the pattern. And in order for you, as the official referee that has been placed here long after the start of this trial, you have now been tasked with this, whether you like it or not. It is your responsibility. So if I'm putting it in my motion, it is for you to go backwards. You can't pull, well, from this point forward, because that doesn't work. Because as you know, and as you see, a lot of things have been kicked down the road in this trial that we're seeing being litigated right now. These are all things that were trying to be litigated with Glanville that he kicked down the road. She still has a responsibility. And so that's where, all these Rule 22s that are coming into place right now, it's like the more the merrier, but do it and make a difference with the fight. Because if you just stream it and you just talk about it or criticize it, nothing changes but your stream. The men are still there. They're still fighting for their lives. And to be honest with you, I'm always careful what I say because I don't want to say something that could be hurtful to the young men. And sometimes when you get caught up in streams, you don't realize that some material can be hurtful. It's just the way that it works. So I always want to make sure that I'm coming from an educational side and a reality side and an experience side. And if I've seen it and I have had a part into help, then that's a different. I'm just not, I'm not ever going to stream it. And I hope that don't disappoint y'all. I'm going to give you the material that I'm working on, the material that I'm looking at, and the material or the letters or what I'm trying to do for policy wise and politics wise and for change. But this channel is strictly for that. This channel is not for a Rule 22 or to stream. It says, yes, motions can enlighten Whitaker. Keys Mobile said, I never seen a state where people are scared to protest for the threat of being thrown in jail. Well, Keys, there's a difference on how you do it because regular protests has been seen to be in a negative light when they're out of order and you don't have the proper things in place lawfully to make it legal. That's when it becomes a problem. So knowing how to do it is a big one. So you have to do a call of action of what we had talked about on this channel, and you have to go through your petitions first, but you go to your lawmakers. And from your lawmakers, you can move to a permit through the assistance with them, and you could be able to put your people in motion at that point. And that is what we are zeroing in on. When you do a silent protest or a digital protest is two of the big ones that people do nowadays for just support. But you don't want to get into that area. I don't think that they're afraid, Keys. It is the digital and the virtual. You could be charged with terroristic threats or threat of their system. So when they think of protests, they think of attacking their system that withholds the information. So you have to be very careful about which ones you imply because it's very specific in the law that when you put certain ones outright and announce them, you can potentially have a charge for different things. And that is why we do it for my business, for my firm, a certain way is because we always want to make sure that we are not hurting the case, number one. And number two, we're doing it legally and lawfully. And we're able to then put our name on the dockets to speak, if that makes sense. Did that help a little bit with the? It's just different things that you have to do, in order for it to work. Um, says, "I didn't mean it in that way, more or less the threat of exercising that right." Yeah, that right is for everyone. The right is for everyone, it's just long as you do it the right way, because with when you are dealing with a courthouse to this magnitude with these connections with each other, and we have seen the behavior of a chief DA, and a deputy DA, and we have seen the things that we've seen, and then you have the district attorney with these ties. You have to move strategically, and you have to move the right way, because there was a protest out there, in the beginning, a while ago. Kevin Crump was also out there. They were there for a case, and then they had, um, spoke up on the YSL. They were all out there, and they didn't want him out there. So we just make sure that we cover it in a way that it is going to be beneficial and not harmful. And that is where we just always want to make sure that it is, the right way. And when you do it the right way, it's respected, and it's respected when you go in front of these politicians and you go have your moment in there to lay it all out on the line, because at the end of the day, they are your help. And so I don't care if this reaches 29,000 people or 2,900 people, as long as they have the correct information and they're going to help along with the fight. Now, I know my people on my page, I have lost a lot of my people. I had my other page since 2014, and that page was taken from me off of a situation that had nothing to do with me. So I had to start a second page over. And unfortunately, there's no way for me to go back and to let my other ones know that I'm here with this name. And so it was really a detrimental overturn of what occurred. So I'm starting to see my familiar faces come back now. And, I think everything happens for a reason. I feel like when you do things with good intention and you do things with a pure heart and you do things genuinely, it comes together the right way. It might be slower, but when you do right, you prevail. And when you have good within you and you're doing it from a good space, you prevail. It might take longer, but it's worth it, if that makes sense. Because I think we get caught up in the day-to-day chaos of the courtroom. And that's why I try to just get what occurred during the court, and I just try to watch just the trial, because I don't, for one, want to stream it and talk over it, because for me, that's an annoying part I need to hear. I need to listen twice and speak once when I'm taking in the information that is going to help me, with anything that I'm doing. And then number two, I feel like when you take everyone's different opinions about things that have no substance or no weight that is going to help the fight, for me, that's a distraction. It's an added distraction into it. And there could be something that maybe I allow one of y'all to say, and I come out and say, oh yeah, this, that, and the third. And then guess what? They go to court the next day and it's brought up. And guess what? It's negatively affected the defendants. They already have enough fight. A RICO is a lot of layers of fighting that you have to do, number one. Number two, they're dealing with direct hand-in-hand conflicts. Number three, they are dealing with straight up and down a whole bunch of alleged corruption. And when you're dealing with that type of triangle, you got to keep it tight and you got to keep it right. Like, there's nothing that you can do for clout because it will be harmful in the end, either to the young men that are fighting or to your own self. And I'm just not going to put that message to the people out there because you guys are genuinely interested in the change, the dynamic, the fight to so you don't have to have your children deal with this, your grandchildren deal with this, and help to prevent and create these things, these conversations to go in front of to the ones that make these very changes. Politicking with Mel said that's messed up, but you're bouncing back just fine. Thank you, Mel. It was a big one. It was a big one because I had that page since 2014. And so we did a lot of good stuff from that page. And I had to go back and try to remember the main people that I had that were actually helping with some groundwork. And like I said, I was really happy. I was able to see some familiar faces last week. And so I know that it's circulating. I had to restart this channel with one subscriber. And already, I think, up at 4K. So they're finding me again, but it will happen. Beautiful One says JC, but thank you, Mel, wholeheartedly. Beautiful One says, JC, what do you think about Fani not showing up for her? Oh my God, a Beautiful One. That is that's what I had for you guys Saturday. And we haven't been on in a couple days. Beautiful One, that is going to be a terrible mess. Because I know where Mrs. Willis is coming from down that line. She's like, you guys don't have the authority to impede on an investigation. But what she doesn't understand is that secondary part of it is they actually have the authority to get all of this information. And so not showing up and now it's being litigated. I mean, they literally can have the power to say, okay, well, they need to be held accountable, XYZ. They can have a arrest warrant. They can have things that are happening, and those conversations are being held on what is going to happen. I think her not showing up set a tone, number one. And number two, her showing up for her daughter roadside with Wade is going to give her another layer that is going to end up ruling against her, because ultimately Merchant's firm, what they had asked for are open records and they're legal and they should be given according to what the law is and the rule is for open record. And so it's going to be an interesting dynamic. You did see that they did drop two of the charges because it had came back that Fani did not have jurisdiction to give those type of charges. So it is going through. They are They're saying that it's supposed to start back in December, but they are still moving forward with her removal. And now she also did not comply with Jim Jordan's subpoena, who obviously, that is the chairperson of the higher Senate or the White House. And so that is a big deal. It's not just that one. You got to remember there's the secondary one that we had covered, and that was Jim Jordan. He issued a subpoena as well, and it has not been complied with. So she has both layers going on. She has one at the state capitol that she's dealing with the commissioner, the state commissioner, and then she's dealing with the chairman for the United States that has done the subpoena that has not been complied with. So Jim has made a big deal out of it. He has come forward, and it now is just showing that this other one, they even checked the halls to see if she was coming in late, but she had put on record with her attorney prior to that she was not going to show up before them, that she had made it clear, and she had an appointment in Washington. And so with that coming out on record, they're obviously going to connect the dots, and put that all together. And they're going to ultimately see who is giving her the advice to not do these things and to go against these things, and how they are advising her. They have literally just put her in a whirlwind that is new for her, because this is her first time in seat. So you can't say that she knows everything that they're able to do and not able to do, because as you see, they are able to pull things together very quick and make a ruling, and it stands. So now she's got the layered. Slick, I just seen your comment, said it's official, Mel just earned her lunch. Hey, and says, where's Des? You can too, Slick. Don't hate. You came over just fine with the UND, have been supportive. You guys do not harass me. You guys are always supportive of me. You guys give support since you guys have come on this platform. I don't have, except for you just try to do me so wrong today with that. You knew that was not me. Krause is not going to get recused. I don't believe so. There's not a reason to. She didn't agree with it. I mean, I don't see how you can fight to recuse an order that the judge made because you didn't like it, but you didn't put that motion forward when you had a chief judge that was wrongfully holding ex partes. So Beautiful One says she misappropriated $2 million for rape kits, and I think $500K for children. So what we did on Reveal, Beautiful One, in our earlier videos that we have here, was there was a children youth fund that was taken from, and that was for special prosecutor and special grand jury. And also 4,000 rape kits, they were forfeited for the funds. But they said that that money was for the YSL trial, not the Trump. And so I think that's why the open records and what they have requested is going to give a clear cut. Excuse me, because my earlier videos had shown the breakdown of exactly how they are funded and where the funds come from and what are the exact guidelines. And I tell you, they give it to you and you get them in big numbers, and you get them dollars, that's for sure. There's so many different ways to pull from it, but the bottom remaining factor is Every single penny got to be accounted for. It does not matter who you are, what you do, what your position is, what your power. If they give it to you, you have to show them in exact. And when it's not accounted for, that is a whole different can of worms that are open. Says, wow. Big Slick says, I told you what I'm gonna do. Oh, oh my goodness. Oh my goodness. Um, Key says, so if you raise the wrong hand, can you still be held to the swearing in? Well, who raised the wrong hand? Beautiful one says, subpoena can get you arrested, can it? Bonnie's daddy better mind his business if he isn't. Yeah, there was a lot that was testified to, but I mean, I can see that he will probably get called again due to the nature of her testimony. Um, and it really seems Democrats are also fighting with her. She's gotten fire from Democrats and Republicans now. And so it's both. And so what the word on the curb is that in May, when she won her primary, was the running opponent didn't have support anyway, as if that's why his numbers were so very low. Also, all of the exacts of these cases and the county and the taxes and the stuff that is happening has been brought to light by these same very politicians. Excuse me. So you have to think of the ones that she had their vote. You do know that Republicans operate in a very different way where they don't come out for primaries. It is a history, it's shown, it's statistics. They don't come out for primary. I don't know why they just don't. It's not a thing, but for election day, they do. But right now, she is under fire from Democrat and Republican. And so she is thinking it is because I'm doing my job and I'm doing my job. And it's because I'm a Black woman. And that is what she is putting out there. But really, ultimately, the people that voted her into seat expected different behavior because everything that is on the platter right now today is everything that she alleged of Mr. Howard when she went up against her boss in running. In which, fast forward, I can see Love running against her on the next go around, if that were to. I don't I don't know, for some reason, um Love wants a DA position, hence why she went for a DA position and she had lost in her county. And so it's very interesting to see that dynamic where she's not going to give up that standpoint of it. She already was looking for it and didn't get it. And so you got to look at that. And then you have her boss. What is the connection between them two? Because we showed you on Washington Post, she said, Willis said she doesn't deal with bullies and nobody working underneath her. If she finds out they treated you some type of way because of your education level or you have been bullied, that it's not tolerated. So with those two hand in hand, and those are the exact tactics that have been taking place right now. And that is what we're seeing. What's the next stop? So there's a lot of dynamics here. And then to exhaust the amount of resources for the county, your taxes have already tripled for your people. They're not directly affecting you because you don't live in that county. And so they're not a direct effect to you, and your salary has increased, and so has your key players on these RICOs have increased. But we have seen that your entire office didn't get an increase as we pulled the different names that are on the website. And you have some of them making the same amount when Howard was there. So her key playing people are the ones that are getting the higher dollar right now. And we shown the payroll on that. When you give more money, they do what you say. Money talks and BS walks, and that is the way of life. And so, operating under that, you have the county that is dealing with that. Now you got Miss Kramer that does her official press release. She has White House experience. She doesn't have prosecutor experience. She's an attorney. She's litigated on the other side of it. Wouldn't be hard to do it on the other side. It's a people seat. It's not that she's lacking the legal experience. She's done White House work and was able to be credentialed, but she lives and breathes that county, born and raised that county. So that county is going to hold a more higher value to her, where Mrs. Willis was not born and raised there. Her roots aren't there. Her heart is not there. Her job is only there. She doesn't even reside in the county that she's over. And so her direct being affected by her choices are not happening in a living way, in a tax way, or in any other capacity. But then you got all these legal ramifications that are coming up. Because she has put on record their relationship has ended. I did see on the news where they did say that that was a county vehicle that is assigned to Mrs. Willis that Wade had pulled up in. And they said that that is a issue that they are looking into. And that is what they had alleged right there on national television. And this is for all the people to see. I mean, you have to look at the state of the affair that Fulton County is in, between the courthouse, the jail, the housing unit, the commissioner's office, and you got all of these different dynamics. And you can tell by the way the sheriff addresses the public and how he addressed the commissioners in the Senate meeting when he showed up with his sister in crime and brother in crime, as they stated. Or she said, my brother in crime. Let me get that correct. And he said, his sister. That dynamic, as I told you guys, was very concerning, because here Labatt is coming close to the end of his term where he needs those votes come December. So with that, looking into that, and you're just now knowing how to get on a docket to speak to the very same people that have been funding you, is incredibly crazy. Like, that is unheard of. I have never seen people in these positions in any state or county fight for lack of less oversight on the funds. We need that money, but we don't want you giving us the approval of what it is. And you heard his argument. Well, they wanted the exact manufacturer. They wanted the exact copy of how much it costs. Well, they had gave all rounded up numbers. Well, I think the accounting department, you have to think this commissioner has been in the seat for terms over decades. And the financial side and division of it has been in seat for many office and election. So they have held their seat continuously. The only two new factors to this is Willis and Labatt. Everybody else has already been there. So this is what occurs when you have two new people in power in position. There's nothing else new that is around but these two, and you have all these different areas crumbling. That is where you're going to have the politicians start putting their hands in the pot. That's when you're going to see higher up start grabbing, but it never works out in favor for the new ones. It never works, and she's getting it from both sides. And unfortunately, the one thing that she keeps bringing forward is a race card. And that is her power play that she is playing off of. But she has both sides equally attacking her of all different races. So it's like it's not going to work because all they look at is the reports, the actions, where the money come from, where the receipts are, and every single piece of it is trackable. And when you withhold any type of reports or any type of records that legally have to get turned over and you ignore subpoenas, you normally don't see that type of relationship coming from a district attorney. You see a relationship of respect to higher politicians that definitely can have a hand in your livelihood. And so I wouldn't think that I would play those type of strings or play on the strings of the few people that you are connected to in Washington, because I can tell you when it all unwraps, those same very people you will see will not cover her. They may to your face while the fire is heating up, but once it's time to cook, they won't be right there. I have been a part of politics for many years, and I can tell you, I've seen this happen to a small extent, nothing as major as right now. And they literally hung that man every which way and had lawsuits that were just flying. And then they had charges, and that it was a mess. And I told you guys he ended up getting sentenced. Like he lost all his status. And so if I were her, I would have to think of your livelihood. If you're starting a new life and you are with this man, and you and this man got something worth fighting for of what your connection with Mr. Wade is, or whatever it was that brought y'all together, and you find it, it is good enough to risk your job. It is good enough to have him driving, quote unquote, allegedly a county vehicle assigned to you. It's quote unquote to still have him there, and what you had done for him has been unfounded. And you said a neighboring county could have paid him double that or triple that, whatever her words are. We had already shown you guys that he was like 100 and something % over the state average. And so it's not that you're being cheap. You have to work with whatever resources your county has. And because it is greater Atlanta, and it is Fulton, you have extra resources to pull from that other counties aren't privy to, but she is. And so it's a lot easier to mishandle the money. It is not particularly good that they have found 3 whistleblowers have had ramifications happen to them that were against the law, which Jim Jordan on just this past Friday reinstated one of the whistleblowers' rights due to that. And they had the attorney general in front of Jordan on Friday, and it was ugly. If you guys have not watched that debate, please go watch it when you guys are free, because that was a very informational piece, and it has to go with what we're seeing on the Trump trial that ultimately trickles into the YSL trial. It is the same shot caller. It is the same reporting person. It is the same everything. So when Love put it on record on Friday, when Whitaker said, I hope you're not calling no more attorneys because that didn't work out good for you the first time. And she was like, well, no, we won't be doing that. And she said, I didn't want to do that one or whatever. She said something to that effect. I can't get her. It was something to that, not exact quote. It was something to that. And you have to look at that. Then who's telling you? You're the chief. You've already put on record you are head of this case. You are running it ultimately. So we know Hilton and Atkins didn't make that decision. We know that decision had to come from Mrs. Willis. And if she's willing to discredit attorneys for the benefit of the case to go the way that she needs it to go to fulfill her promise, that's a problem. Because all this case is doing is sucking up resources that your county could use, your county's in need of. I know you don't particularly live there, but there are people that do. And then you got Kramer who's standing up to say, I'm here. I was born here, I live here, and I'm still living here. And this is what's happening, and it's ridiculous. So do you take a chance on someone who really cares of what she's trying to put out there to the people and trying to give clarity? Or do you stick with the same person and think that she's being attacked because this is what she's putting out to the public? But just on her, she said it's ruining business. She just said it when she did her appearance on Friday. She said she was tired of it, wanted to move forward because it's ruining her business. And I don't know what she meant by that, because I know she has her own personal decorating party business. She can't be talking about messing up business is in the DA's office. But this is some really nasty groundwork backdoor. It's like when you run a play for the underlay, you got to do what comes with that. Because I'm going to tell you, you can't one up them folks on the money that they give, especially through grants, because they nickel and dime that grant money because they didn't want to give it in the first place, and it don't matter who you are. And then y'all are pulling from extra emergency funds, and some of them can be allocated to your neighboring counties because some are a state fund. And because you Your area holds the capital and all these things you have, and the airport, you have extra resources that your neighboring counties aren't privy to. So that's taken advantage of. And that further lets you know there should be no deficit within your county because you have the most resources to pull from. So keeping you have the most resources to pull from, you look at on the other hand, if you think that you having all of that within that county and they're not going to nickel and dime and keep track of everything coming out, you have to remember they've never seen numbers come rounded up for approvals. It's not normal for them to not take part in those meetings on the agenda because they are the key players to have the information to those parts. So both of them coming up on term for their seat for reelection is disturbing. And then no type of etiquette in there. You can't walk in and demand what you are telling them what to do. They will deny you coming in and going out, and there's nothing you could do legally. Her legal power goes to a certain extent. And I know a lot of people are so intimidated by that. And that is the reason why they have provisions in place is when things like this occur. And unfortunately, her attorney gave her some very bad advice. Don't show up going about your way. Don't comply with Jim Jordan, all of that. Regardless of the situation, your position holds a certain precedent where you have a duty to do those things. And so there's always that end of it. And that's why we posted all those documents for y'all to be able to see and break down those type of fundings and break down those taxes and break down all of those crime reports that we put up to show y'all. You can't go off of what you hear because the biggest devil of it all is the media. You got to think of, if you really think of it as a whole, when you have a president campaign going on, like right now, you got Trump and Harris going back and forth, back and forth. What do you keep hearing on the news? That they have polled and this person's winning, that person's winning. I'm old and I already have a grandchild. I have never been polled in my life and have lived in numerous different states. Where are they polling from? Because early ballots just came about. So where have they been pulling from? A lot of people don't really think that far into it. It's just a lot of nasty groundwork that is being uncovered, and unfortunately, the mess that is happening within the Trump trial is trickling over with this YSL trial. And that's exactly what's happening. She's going to end up with double heat off of Love and Hilton's actions and Atkins. And I got to throw them all in the same pot because if one of them did not agree with it, they wouldn't keep on pushing the narrative that they are pushing and doing the things that they're doing. However, Atkins did look a little bit surprised, I want to say on Thursday, when some information came up, and again on Friday. But then again, are you really surprised? You work with her day in, day out with this case. Who is allowing y'all to be dirty? Who's telling you it's okay to play dirty? And who has allowed these tactics to keep on right now, even with all the conflict of interest and the relationships that have occurred and all of the factors. This YSL trial will ruin her before the Trump trial because, excuse me, on how they have worked their self into this trial. It's going to be some nastiness that is going to come with how much stuff that has been brought about. I can tell you that the state bar and the prosecuting counsel is really going to have a lot behind this one that I can tell you they didn't expect coming into this trial. I think they thought the notoriety was going to be great, but how they went about it and their lack of knowledge of RICOs and how complex and how strict the law is with that, I don't think that if they knew that then, they would have not done any of the things that they have done. They would have backed up and they would have been like, I can't do this for XYZ. And this is going to prohibit because of XYZ. I can't do this because this is against the law and the oath that I've taken, and this is playing dirty. I can't do XYZ. But all of this stuff has already been done. It's no taking it back. And it's all laid out on record. And it don't help when you have your local Senate and your higher Senate, and you have your commissioners on every level that is zeroing in. So now they got all this Trump stuff they're weeding and seeding through, and now they just got all these letters and all this communication for the YSL trial. So for them, it's here we go again. We've known some, but they don't know all of the logistics and the ins and outs like they do on the Trump trial. When in reality, they're paying attention to both because they have brought it up. And so that lets you know right there that they are not going to turn a blind eye to one to focus on the other. It lets you know that they want both of the information. They want to be able to deal with both sides of it. And so my thing for the people is, do you guys think Love will take the fall? Do you think Hilton will take the fall? Or do you think Atkins will take the fall? I'm just curious to see who you think the fall guy will be, because there's going to be a lot that occurs from this. Who do you think the fall guy is? Because I can tell you that brief that went out on Steele, the Supreme Court don't save judges. They don't save prosecutors. They don't save anyone. And as much stuff that has occurred, we're at 35 motions for mistrial. These aren't just going to fall into the realm. That's if the jury is back. They said a juror was sick last week and whatever else, and hopefully they be good to go Monday. Are they sick, or are they sick and tired? And as jurors, have you guys been promised anything outside of your $25 a day? Because of the length of the trial, you can request special funds when you have a trial that is taking longer. There are funds that you can request and pull from. He said, "I don't know because everybody thinks it's so funny." Yeah, that's the point. That that's the exact point is there's a lot of things that people are finding some of these things laughable and funny, and it's like, man, there is nothing in this case that you can get a laugh from. There is nothing within this case that you could get a laugh from. The judge's little giggles here and there are inappropriate. Those men are looking at her every single day. They have been there for 2 years and 4 months dealing with this mess, and they still cannot even have an argument on information that has come up a year and a half ago. Because Harvey was ready. And now that he's closer to, they need to put him closer, or they need to fix his microphone because he's hard to hear because of the issue with these microphones. I just find it really weird that these microphones are now a continuous thing and they were never an issue when Glanville was there. And it's the same courtroom. I'm not understanding that. And I would have to see what cords are underneath the table of the prosecution table because Love is forever jiggling or in a bag or doing something up underneath that table continuously. And uh, another pointer, Law and Crime needs to do the right thing and speak up to the judge and ask for the prosecutors to mute their microphone when they are not speaking, because any of their whispering that is coming through is because Love purposely leaves the microphone on. We have watched her co-counsel shut off that microphone time and time again on her when they want her to stop. We have even seen the microphone be taken from her to attempt her to please stop. There has been nothing in this case that has been laughable. It's not only about, I mean, uh, Steele got arrested, bringing forward a motion in good faith. He got the information, and it's his job to bring that forward. Beautiful one says, I think Love because she has been admonished, rebuked after being told about candor to the court. Candor has been several times. And also has changed your information about the Brady. Beautiful one says, HE double hockey sticks, no. Yeah. So it's just the difference of it. It's like you can't even find a laughable point because you're looking for air for someone to be able to put a stop to the madness and to be able to put their foot down on what RICO is and the elements of RICO and what you have to satisfy a RICO. A RICO is layers, and you must have every single ingredient, and they have all expirations and single things that have already been having their time served on. And so, with not having the elements, everything that they're doing right now is a waste of time. Because they're even entertaining things that are outside of that RICO when the law states that you can't. It's not even about the 10 days prior to trial, discovery is due. When it is a RICO and it is indicted, there are certain layers that you cannot go without of. It's not like a regular charge in that the state is used to trying. It is not the same. So most of the things that they are arguing that aren't within that indictment that are coming in, they can shut that down right then and there just based off of that case law that they give. And I can give them 4 cases that it will explain to the T, and it covers exactly what is occurring right now. They're not the first one to try. Yes, beautiful one. When Whitaker said where they were and if it was picking up, it was a problem. It was law and crime's duty to say, Your Honor, the DA's office respectfully needs to shut their microphone off and not whisper in front of the microphone when it is on. And it is going to pick up that sound because they are keeping it on. So it is going to go through. They have 4 microphones in front of their face. And not to mention, to the left of Love, she's got the single stand up solo performance concert microphone on the left of her. Those are the ones you see literally for musicians. So it's a lot of different things. I can tell you right now, Mrs. Willis is not going to jeopardize herself for the actions that we're seeing of Love right now. She ain't going to take that fall for that woman. So her putting on all those antics and all this show in the courtroom and filling in her blanks with her theory and not relying off a case law and just putting in a bunch of fillers and them stacking and really having it being proven to be a trial by ambush. Ain't no way I'm stamping my name to that. I'm gonna tell her, look, you done lost your mind. Or if I feel that it's gonna jeopardize my job because my boss is playing dirty, then I'm gonna cause a damn mistrial. I'm gonna say, I'm sorry, you know what? I messed up. I ain't see it, but I'm gonna have to walk away and wash my hands from that. I'm sorry, but I can't I wouldn't be able to let another person take what I work for. You ain't gonna go send me off and go in that courtroom and fill in a whole bunch of BS in my theory and belief. And hell, I don't know neither. Apparently you do. And I'm getting justice for you because you made this promise. Because when Love said on Friday, well, I didn't want to call him, whatever. What I can't. I'm gonna have to go back to that part, but um, it don't look good. It don't look good. So it's like, why? Not only that, I'm a very I feel like Murphy's Law. I feel like anything you're gonna put out there is gonna come back. You can only do that for so long before it comes back to you. Just think of if this is being done like this in front of the nation, what is being done off camera? I feel like one of the things that I wrote down to fight and have in my fight where every single courtroom across the United States has to be recorded. That they have to have it installed where you can tap into live courtrooms so the injustices of where they are done in whatever city or state that it is, that people within that community can be able to stand up. Because that courtroom right now is like open mic night. You got stand-up concert mics everywhere. You got those ones the news reporters are using. You got the little small ones. And now all of a sudden there's tons of wire issues and technical electrical issues. And when Glanville was up there, man, we heard chewing, we heard coughing, we heard drinking. Um, Everybody talking at once. Miss Weaver is the unsung hero of whatever her transcript's going to be because Love stayed cutting everybody off. It was like you were in a city town hall meeting. Like legit. I have to look. So I I don't know. I feel like it's gonna be too many things that are gonna result from this because they all have a certain characteristic where they refuse to give it up. You're even seeing it in Hilton where she tried to give the judge a little bit of kickback and she was like, I made my ruling. And then she did the same thing with Love. And then when she told Hilton, like when Hilton was like, we're trying to prevent from having to call a medical examiner or to be able to get one or have one to come in because they had something or another. And Whitaker was blue because she's like, this case is on appeals. Like, why would you even be doing all of that? This can't be a conviction no matter what. Like, what are you doing? I mean, he was a kid with another kid that's not even nowhere around. How could you say that's in furtherance of anything? Beautiful One says, remember how hostile Gaither was towards the defense. Why is that? Why wouldn't it be? They're representing the nephews. This was her put together investigation. This is the real kicker, y'all. And this is what y'all really have to think of this bottom line. There's no reports nowhere. Gaither and Dennis didn't leave behind a trail. It's empty. They had a way to where they had, it seems like they were playing a cool front to the guys and then a I'ma get you sucker on the work front. When really you're mad because this man is young, successful. You see the legit team and people, as I told you in my video. The team is all there. And I'm not trying to be funny, but it's like a whole bunch of white men in the room of the video pictures that I have in there. And all these different fashion designers from all over the place. And then these musical engineers that travel in from across the country and they're all together and they are working from it's 5 in the morning and then it shows they're when they're going to bed at 2, 3, 4 in the morning, trying to sleep for an hour or two, doing it all over again. And they want you to believe in your head that all along he's been out there on Cleveland doing all of these things or right off of Cleveland, but the very projects are demolished and tore down and gone for many years. that area is revised right there. So what they're even trying to portray to the jury is that this is the area that they're still running around. They don't want to tell you he owns hundreds of acres of land and what he does. They have not covered any of his philanthropy, none of it. You don't see anything circulating of the good. You see nothing but very, very young. And I would challenge when some of those pictures were reposted, because if you go further back in his career videos where he was starting to get noticed on his mixtapes. It looked the same. And that's about the time where social media, wasn't coming about. So everything, we didn't know then about social media like we know now about social media, and everything back then were never um, like how it is now, where, it's at a snap of a finger, you look through it. Then you would do it like you got home for the day or the next day, or it wasn't as popular or prominent. And so for them to even hold that narrative for the state is really even more crazy. And that's exactly why I did the video, was because nobody has explored that side, or nobody's portraying, because everybody is portraying this criminal trial and all the actions of the DA. Yes, we have all the good fight, and we have, everything that's coming together from that. But at the second part of it, you have to think of the other side too. You have to show the side they do not want you to see. They don't want you to see who the person is today. And I'm going to tell you, Yak Gotti got a hell of a story, a hell of a story. And the way that they demonize his Bodies on Body song is crazy, because he actually had different scholarships for football that was taken away from him because of a girl claimed rape on him, and he was the most popular and already had a foreign car for high school doing his thing, and he got locked up for it, and of course the charges were dismissed. She went to the next school and did the exact same thing, and that they waited 7 years before they threw it out. They took all his scholarships away, and then it showed, and I guess like they waited, and then when she transferred out of that school and went to the next school, she did the exact same thing. Then it was dismissible then, but it already took away all his scholarships. So he made this, he said the Bodies on Bodies, he said, because football players of the NFL were giving him his notoriety, that they love to listen to him during workout, during games, getting pumped up, ready to go. And he said that he used to feel like that was his dream, and that was taken obviously from him, but now he can make music and live his dream through them. And that really touched me. It really, really touched me, because I look at that. I got a son who plays ball, plays college ball. And I always told him, you got to keep everything, right and tight, because you get them ones that you just don't ever know. And I'm glad he's not even, he's got the same one riding with him that's been with him. So it's been smooth. But to look at his life and you look at his stuff that he put, on his interviews where he said like getting his first house and being able to sit there and it was of luxury and he earned it and he worked hard and stayed in the studio and changed everything around for his entire life. He felt like those scholarships came back again. So the way that they're being done right now, they don't want you to see that it was two different. You had the neighborhood guys that grew up with these guys, and they had a few that they learned of, as they were getting before preteen, then 8, 9 years old. And you're all together, you hang out together, you do all these things, together. We all have our childhood friends. Everybody's gotten in trouble in their life. And when you come from an area and a project, of course, you're going to see things at a very young age. I come from a bad neighborhood and it just was what it was. We seen a lot very young. And it was normal for us. It was normal, like dreaming to be a doctor or anything where we come from, they don't go hand in hand because don't nobody have money for that. And that's how you think. It's almost like, you're a product of your environment by default. You didn't ask to be raised there. You didn't ask for the poverty stricken things that you've gone through, but you've appreciated them. And they make you go through life in a different way to where you do grow and you are able to achieve more. And then you realize that, damn, there is a world out there that's further than right here. Because when I first discovered it, I was like, whoa, this is real. Like I had never been outside of my city until I had to start making more money. And I kept putting myself back through school. I put myself back through school 4 times with kids. And I worked. It wasn't easy, but it wasn't normal for where I come from neither. And now they're all grown and I can appreciate it because I appreciate where we come from and how far everybody done grown. But it's still, they don't want you to see these things. They don't want you to know these things. They want you to keep on focusing on all the different antics that you're seeing and it being drug out and all these people coming through now, line up. Look, we're doing Rule 22 hearings every other day now, twice a week, whatever it is. It's just all the antics, but nobody wants to talk about them, who they are. All you see is is that, and then you have a witness that you're saying, "Look, man, I mixed a little truth with a little lie, and that's why nothing was confirmable." I mean, you really think about it when he told Hilton at the almost the end of the questioning. She was like, "Did you say on the call with something, something?" And he was like, "Yeah." And then what did it say on my next call? Contradict. They contradict each other. And the look on her face and the way she paused and stuttered and took time to come back again. And it was the next question even sealed the deal even worse. It's like y'all are upset because y'all mentally don't have them. It's like you did what you could do for the paper wise, but I really think that they thought they were going to puppet it out and they were going to be able to string them, but they know better, as in they aren't the people that you're trying to bring up on that screen. They don't know who that is anymore. They've been so far gone from that. When you live a life and you make that much money and you're successful and when you watch the video and see what the day to day look like, it go to you'll be like, man, this man can't even sit down and eat a meal in peace. Working right through it, working right on and having, just the entire team. So I think when Steele said on record, he's got an entire professional team. He tried to give them, a chance. They made a mistake. He had to send them off. And then there was money he had to repay on one of them making it right. So it goes to show you he was trying to teach lessons to them as well. And let's make this right. But still, you'll never want to say like you're some punk now, or because of the nature of how you grow up, you just don't want that stigma neither. It's crazy when you grow up on a lower end. It's kind of like we're conditioned in a different way, that we don't think how we think when we're older and more knowledgeable. Like I wish I knew a piece of what I know now back then, where I could help so many people and maybe I wouldn't have buried so many. Just to give you guys just a little insight, my immediate circle around me coming up, they're all dead. I've buried every one of them. And so it hits different to be able to see it and look at it and know that you heard the state demonize that phrase for Yak Gotti. I got bodies on bodies. They instantly thought he was talking about shooting. And he actually made that for a player. It's just really crazy to see that the prosecutors, regardless of everything's going to go in, it's just like morally and spiritually, you have to know that what you're doing is wrong. You know that these acts all didn't come together in furtherance of. Yes, Jeffrey is the man. He's successful. That is what you're using. You're using his success as a leader. He's an owner. And whatever his childhood friends want to do when they're back home on their time doing them is their business. And if they want to say they're YSL and connected to my label, and I got love for them, I'm trying to help them. I'm trying to pave a different way, but I'm working. I'm busy. I have to put in all this time so that way everybody eats. You just don't hear that. You don't hear. So that's why I put together the footage. And I put together all his award shows, his Grammy, um, his different nominees, and I put all of that together. And I put Yaks together. It's important to know who you're looking at, what you're hearing, because you can take the information of how they're trying to demonize them, but you can see that it doesn't meet what they look like now. You're not hearing all of these things. You're hearing this man has tried to lend a hand and has all of these businesses. And there's no way you could be in a demolished area that is um, all new area right there. As in one of the questioning with Woody is if that area is still right there. And he's like, I don't know. I'm from Mechanicsville. I mean, clearly he came in at a time the come up was already in play for a long time. But it's really sad when you see a prosecution team tearing up. They're trying to tear relationships apart by this way, by these tactics that they're doing, when really Jeffrey was very close with getting them on a good path and some type of career of what they like to do. It's like you can only try so much, but he still has a responsibility to his children, to, his mother, his father. So this whole thing you just don't see. We're just seeing all these antics with the um, DA's office. And so that's why it was important to get all these letters out and update and get a letter out to the judge. I thought it was very important. And the video, I think it's important. I'm going to debut it on the channel first. And then I'm going to send it in. I think that we're living in a world today where if they feel like they want you, they could do what they want to get you. But this one right here, you're seeing that they are willing to go the mile. They're also willing to lie to the very courts that they took oath in, to try to make this happen, to try to make these charges go through. And they don't even have the experience on how to litigate RICOs, and they don't know the exact substances and the layers of a RICO because they are outside of it already, introducing things that are not within that RICO indictment. They cannot make no edits or changes to that indictment from when it comes of what they sent unless it's a redaction you cannot add to. All of the stuff, the layers is there pointing at cannot. You can't stand behind something that obviously y'all ain't really good at them. You guys just went. You got a DA in place that she's like, I got 11 RICOs, and boom, she smacked 11 down. Two of them are the biggest ones, as YSL and Trump. Those are her top two. And then you got the other 9 that she has says right in her public interview. She got 11 investigating 2 more, or 2 or 3 more, she said on there. And you got an office that's got to learn about all these RICOs, because RICOs weren't served like that because they were really for mobsters. And they were for huge bank frauds and all of those different things. Like you don't see it for no individual nickel dime crimes. You see people on RICOs that they have brought so many drugs into the country by boats, by planefuls, by busfuls, just loaded. You don't see average young kid hanging out in a park, barbecuing, nickel and diming it, and going to jail every now and again for possession of a gun or um, uh, aggravated assault. You got into it with somebody that we seen that was at the club fighting. That it seemed like Crucial was the spot, and that was the spot for the city in that particular spot, according to how many police calls were there overall. Yes, they pulled these little ones, but look how many times police present. They had to have police in there all the time and on the outside, and how many times they were called to there, and these things have happened. We have heard testimony that the detectives worked, one of them inside Crucial. So you know that there is security within the club and there's still these things happening. So it's like you guys are also playing with people's intelligence, but a lot of people ain't sitting there breaking it down like that to make you look at different sides of it that I think is important. That's noteworthy of breaking it down on why they don't have enough. And what they're doing is just really wordplay, playing on people's intelligence. And you're pulling out these CAD calls and you say, "Oh, he had a situation." Well, yeah, he got knotted up. I can tell you back in my time, we did have a club on our side of town that was the spot for everybody, male and female. That was a spot to go to, and if somebody nodded me like that outside the club, parking lot's gonna get it. That is the way we operated. That just was your nature of how you grew up. And so to see these things conflicted and see individual things happen, everybody, when you're coming up in that environment, you're bound to make mistakes because of the conditions that you're in. So that could easily be used. But you're reaching so many years back, you got to bring what they're hearing now, and they're downplaying it so bad where they're disrespecting them. You see them getting up on stand getting disrespected by these DAs. They can't even talk to them right because they got them so mad because they are not giving them or talking to them the way that they intended. What are they saying? I know you're doing your job. I'm not trying to give you a hard time, but then also have to say, I'm not, talk to me the right way. Then you got Woody like, look, I don't want to disrespect you. I know you're trying to do your job, but I lied. This not the way people that have RICOs, our witnesses are coming through, y'all. They don't come on the stand like that. They thought it was gonna be a show for the jury, and they were gonna put their it was gonna, the way that they put the pressure was gonna give them what their belief tried to tie it together. But you can't tie together lies though. And you can't tie together that's something that don't match, because no matter what you rely on them to say or you're filling in the blank, it's never going to slide the right way because morally is not right. And you keep hearing from every single one of them, like, God, God, God. I keep praying, and God, God, God. That's not what they want to hear. That's not what they want before that jury. They don't want that in front of that jury. But that jury's mind got to be mind effed. Everybody talk about the simple things and all of that, but you have to look at every single side to it, and the motive and the way Gaither, um, I don't know, my spirit, my intuition is, I tell you, me and my intuition are best friends before my knowledge and my research. But we had a Gaither in our neighborhood. They dangerous, Jack. They worse than a criminal. Because they can play real good in your face and they play you so dirty behind your back because of their ties. We had a Gaither in our neighborhood, but he was a guy. But one thing I can tell you is we ain't never seen the prosecutors out recruiting or talking to nobody in our streets. You dealt with the police only. We had jump out boys. There were certain investigators that will go through the hood and they jump out on you. And if they just want to talk to you, they chase you down, do whatever. I never seen prosecutors on our streets ever. And they ain't coming in to ask nothing. If it ain't through the attorney or in the courtroom, it'll be through an investigator, but you'll never see them in any room talking to you or doing any of that. So listening to the prosecutors, when we met you at Wendy's parking lot, when I met you outside and you got in my car or you were outside my car, or when we went to the coffee, I ain't never in my life heard no stuff like that. And you know that the two pride Gary and Wasser, the two DAs that quit, not the case, the entire case and office before Hilton and Love, they know something. And I feel like there should be accountability and questions with that, because if you got an oath and you are working in a capacity of a official of a court, which they are. And I know she got a higher position now that she done left there, but still in all, if you know something and you're silent, you just as guilty. You just as guilty. Because knowing something and not allowing this type of stuff to happen, knowing good and well, and then on top of it, to try to label everybody together and not everybody know each other. And you have these severed off defendants that is a big old confusing mess, to where they're wondering who each other is. Not everybody know each other. So not only you don't have the people right, you already know the founders. They didn't identify, put it all out there for everybody. You also got that going on the side. So you have to make it make sense on the front end and the back end. You say, okay, so where did the motive and information and belief? How can you have ones that have hit the stand, but one that didn't? One was represented by the person that's pushing this indictment that went for it, but kept you off. You're a founder though, but you're saying this is the founder instead, but we heard different. And this other one, he's saying, well, I'm the co-founder. But that don't apply no more because we said it's you. And then we're going to say that they are all connected with you because they've been on tour with you. So that's your inner ones. And then your other ones that we're going to connect, your childhood friends, we know that they're going to plead out because you're not dealing with them every day like that. No way. There was no attorneys paid. No, none of that. You got in trouble. Everybody had to deal with their own stuff as a man. He tried to give them legit hustle You either take it, you don't. Some did, some didn't. It is what it is. But you don't get to do it like this, where you're putting what your information, what your belief is, and making up things and throwing everything in and hope it sticks, because you're going to use what their previous charges from young on up. They're not old right now. They're still young right now. They're not old right now. So you go back, all them, you got to go back a decade and some more. You know that's their young and dumb, growing product of environment time. And you got to try to throw it all forward and say that it was all in furtherance of something that he built along the way, that he has documented in my video, documented proof that this took him to build from the ground up, morning to night, every day. Like, this is sad. It's really sad. And you can see that your very constitutional rights can be at liberty at any given moment for information and a belief. You'll never in the history of the United States see another witness hit the stand and say, I lied. And y'all know I lied, because then nothing add up. That's why you couldn't get it the first time. You'll never see another murder thrown around, being charged everywhere, that they ended up with. They were with the witnesses first. They got a deal, they're witnesses, and now they're with the other side, and now they got those, and they got to go through that cycle. And then it's a never ending thing until if something sticks on them. How is that justice? Nobody's getting justice. And what they, the longer the case, the more air. They are really, really crazy to keep prolonging and thinking, adding and adding and adding and adding people in is going to change the dynamic. But once the defense needs to put foot on necks right now. Right now is the time to bring once this with little D situation come forward, they need to throw the history at Whitaker, because that's your job. If it ties in with the current and the past, and you have to look at it to consider, because this is a reoccurring thing, you have to know about the previous. And so we're going to stick on that. And that's what we need to deal with right here. But I think there needs to be a lot more firmness. I think that they need to step it up, and really, when the boy, let the judge tell the defense they ordered them to do something and they don't do it and don't have it prepared for the state. Love and Hilton are going to get up and cut up on their behinds. Do you hear me? They are going to cut up on their behinds, no doubt. So for them to be silent when Whitaker is saying something, is they have to, the pressure, they let up the pressure when she pushed under the roar for all of the ex parte and all the prosecutor. I'm still going for that. Y'all have to bring it back hard right now. That there's not a choice. Like, it has to happen, because it's being quieted, but They would eat the defense alive if they have missed that many deadlines. And if I were the defense, I'd go back from the very first day where she said, and lay down her rules. I'd include that in the motion with the little clip from the Law and Crime. And I'd go to the next one when it her first time where lack of candor again, didn't turn over evidence. Brady, I'd include the um every little piece and put it up in there. Every little piece and put it up in there. You have to. You have to. And you have to fight for this is necessarily my witness. I got locked up, lady. This I got ordered. I came out my jewelry, my coat, my tie, got walked out the courtroom. And then when they was done and Glanville had to bring me back, he expected me to finish the day, told me to put my tie and stuff back on. You think I can finish and think and advocate for my client the rest of the day and you just got me locked up? You just sent me to jail. Whether I made it down there or I just made it to processing or wherever I made it to, I was not with my client. And you proceeded. So that's a whole different situation. It just needs to be amped up on a secondary, third level now to be able to put the hammer in harder because the state is getting away with things. This little D situation, they got to put this down and they need to bring up the warrant situation of the previous, all of them, even from the warrant, the initial warrant that Quinn got. Sure does. It's just a lot of elements that they have a right to, and how they present it is going to matter. Because it's almost like you have to force Whitaker to see the whole picture because she's not interested of going backwards. But she doesn't understand it's been so much tied to backwards that's in the present that is being brought up now, or witnesses that are just coming about now that were talked about for months. And so she doesn't know the significant or the weight. And that's why it shouldn't even been allowed. A mistrial should have just been granted because you have a trial for this length of time. It shouldn't be. And I understand when they had their little bond motion hearing this last one, they had said that the trial has been going on 11 months, or they said something, or it was longer than that, he said, but he didn't include the jury selection time and how long he sat. I felt like the whole entire, say it in years, because that makes a difference if you say, oh, it's been this many weeks, or it's been 100 and something weeks, or a couple months. No, it's been 2 years, 4 months. Let's talk about it. And then you hit them with all the stuff that I said earlier, with all of the Mandela rules. Like I said, I wrote down over 55 something on there. Had to put together a whole longo speech, which I did. I made it as an attachment, and all the rules in the pre-trial detention. So it's you can't play dirty with this kind of stuff, and then you have a RICO, and then your staff, your workers, or your not your workers, your DAs don't even know. The familiarity ain't there. So they thought like it's a regular case. Oh yeah, we could stack this, we could throw this, we could add this. That's how you know they do not know RICO. You don't see this kind of stuff in RICO, and I can see why the feds turned it down, and why Howard turn it down because it's filled with information and belief. And he probably knew Gaither. You really have to think about it. The investigation started off of Gaither and Dennis. And then you fast forward all these years, you got to go down all these years, you got to go a decade up. And now you got Love and Hilton carrying out, trying to explain what they was doing from the information and how they got it. You know they know that is Little D. You can't tell me they don't know that. Ain't no way they don't know that. And they worked in the same office. So they're trying to explain. Now, if it's true, because allegedly the father said Gaither got promoted and was ignoring 911 calls. What else do they know? So you can't explain playing both sides, and you can't explain being dirty. That's when it get filled with information and belief, and you get caught in lies because you say one thing and then you might have to double back for information and they might tell you something else. It's like dealing with Woody all over again in a whole different way. But this one got a badge. And somehow they were able to convince Glanville that they experts, which probably even surprised them. And you could tell that it was a big hype for them when First 48 came there and highlighted the city, and they had Thorpe on there and Gaither. It's like they were almost like trying to portray themselves like The Wire, like the movie series The Wire. But for them to not even think of, like, they have already said on record, some police were letting them know they after you, or they're doing this, they're doing that. Every I could probably speak for everybody in poverty when I say this, because I hear everybody kind of in a whole bunch of different interviews and just on TV interviews. I want to say everybody, but everybody knows an investigator or police officer that's dirty, that plays both sides. Every hood has them. If you're really gonna keep it real, every hood has them. And when you're looking at a successful man and you're looking at your entire salary that you make in a year, he makes quadruple that in one night at a show, at a regular show, not even a concert. I'd be mad too. And she probably thought she was close enough to the circle to have some type of, I wouldn't be surprised if she has to be put on as security or as some form of worker. I wouldn't even be surprised. They've left no trail, no reports, but the guy you were dealing with was the administrative coordinator. He dealt with records, red flag, Gaither, red flag, Thorpe, red flag. All the dealings and all the people that have been affected along the way for y'all to put this case together. You even had investigators that were just looking out for themselves. They were looking out to get some. They weren't trying to help the trial. So you have everybody that comes and covers all this stuff on a day-to-day basis, but they're not giving you every dynamic. You're getting just what they're doing, and some of these things of how they're acting laughable. This is disgusting. Y'all are watching them railroad these men. Y'all watching them be backdoored. You can't be angry from a keyboard. You got to put some work in it. It's just, that's that's why I always tell you guys, like, I'm not interested on that end. I know that I got a couple messages asking me to put the trial up during the day, but we're working all day. I have the trial on in the background, and then at nighttime I have to go through the pieces of it. I have to piece it and then, come up with, my evaluation to be able to send in. And it's sad seeing that, so many people can find laughable moments, and even the judge. Because her laughing times that come in is when it's usually when it's critical information that have been talked about for months previously, that she's just blowing off and want to hurry up and rush through. And she'll rush through any type of video. She hates to watch a video. But to even allow the state to even try to call this many more witnesses for acts that have been committed individually that they can't even find, or anything outside of that indictment, y'all are even crazy for allowing court time to even be put on record from it when you got case law that supports that they can't. It's not RICO. RICO is fact specific and written as such. It doesn't, and you definitely can't go for RICO with no beliefs and theory. So it's going to be interesting to see how it's going to be handled with the Little D situation and what's going to come from that. But that history needs to be given. Whitaker ain't going to have a choice on this one. This lay witness was violated just like the other ones have. Bennett was violated through sexual harassment, and that's wrong. Lost her job, had to meet, had to bring her son with. She was uncomfortable. How they trying to play this whole thing with Little D? They did that. They backdoored. They did that man wrong. And you move them now to a medical facility because you had static all weekend on y'all heels. So y'all know you couldn't come into the courtroom tomorrow knowing that he was in regular pop. He's been in regular pop for the most critical time after his transfusions. So you can't escape that part. And you can't escape the part he's a lay witness. Y'all let that subpoena cover. If it was about making sure he had the subpoena, like y'all said, then serving him at the hospital would have dead that issue. But you took him in for what? Do we got another Woody situation? Are you intimidating him of what he could possibly be charged with if he doesn't come and testify? He got to come tell what has occurred to him over this weekend. And he got a very vocal father. And the mother has said you get in contact with the father. That's what she told them. You deal with the father on that. She has to deal with her sick son. So you're not going to come stress me about something that anybody has said about my son, because my son had a charge and he did his time. And then they coming out here to have to put it through, but they dealing with this real life situation, and they're in middle of being backdoored. This man was taken into custody after transfusions when he has to go home and follow your discharge papers. Rice Street ain't giving it to you. People are going in and not coming out without medical conditions. And then Dee says it's distasteful people running to be a part of trial so bad that calling the witnesses and the family for views knowing they watching. I mean, you can't, because they're gonna tell their story. And it's like, yeah, you want to put it out there, but they've put it out there already that this has occurred. We've heard about it in court. He's sick for more than a week, more than two, more than four, more than 2 months, more than 3 months. The nation has known that little D is sick. Everybody knows of his condition. So when his father came forward and said what he said, that should have been enough to solidify right there. This another situation to add on to the other situations that have occurred. And this time they have taken in a big medical liability. But that doesn't go against, still, he's a lay witness, and you can't use the excuse it was just about serving him a subpoena. You could have served it. He was there. And if his father had already said, and he already told y'all that when it's subpoenaed, he'll come, but they not coming up here talking to y'all and meeting with y'all before that. My son did a crime. He did his time. He's done with that now. There's nothing over him. You didn't like that, so you took it your way. That does need to come out. His father should be called to the stand, and his son, I have no doubt, won't put it on record if he's forced to testify or they do anything. If we see any forced immunity with no type of charges or something, you know it's something in the game. But it's how they're going to answer to it tomorrow and how the defense is going to handle that. I mean, I was on the case, they'd be tired of my motions because I would have to file them every day, and several. I'm sorry, Judge, you're going to have to rewind. You're going to have to go back to where you don't want to look into. You don't have a choice, because we all been anticipating this for the duration of the trial. And had you been present, you would know the importance of why this is a big issue right now. And the way that the state has been allowed to be unprepared, well, it's hard to be prepared when it's not there. And when you're changing your information and your belief and your theory back and forth, and you know that these men's life, the least thing you can do morally is stop fighting a bond and show you have a little bit of humanity. That's like the bare minimum, and y'all are still withholding that, but you have proved time and time again that that very same threat that you've used for every single one of them, that is null and void at your say so. If you do what I say I tell you to do, you can go. And since they've been out for so long and they haven't been back through the system, what would be different for the ones that are here that were living a completely different life day to day and have professionals and footage? It's like you can't You can't do nothing to for clout in situations like this because these are straight travesties. These are straight travesties that's occurring, that's happening to these young men. And love operates as she's shellless, as if there's no inner, it's empty up in there. So you think that it's going to improve and they're still making calls to do that? They're not thinking of outcome or what's going to come out, and it's clear. And why I say it's clear and it shouldn't be arguable. Look at the decision they just made with Lil D. After all the heat that they got right now, this is the decision y'all collectively decided was in the best interest of the state. Ain't no way that this is your way. Ain't no way. Ain't no way that collectively y'all didn't think that this was going to spin back. And for love, especially, why would you want another medical incident under your hands when you got the issue with the gentleman that passed away on your hands? What would make you even want to take in that liability? Ain't no way. Ain't no way. So that lets you know that I'm gonna operate it the way I want to. I'm gonna do it the way that I want to. I'm gonna get them however I want to, as long as I get them up in here. And whatever way we handle it is the way that we handle it. Because if they were proceeding on the air of caution, they wouldn't even touch the situation that way, as if they was heartless, malicious, and it's a lay witness, and you don't see lay witnesses go to jail being discharged from the hospital for a subpoena. He didn't say I won't be there. He said, I'm not coming up there to talk to y'all. You just give me my subpoena, whatever the time and date it says, that's when we'll be there. And because he said, I'm going to plead the fifth, you can't be mad at that. He's done his time. He's paid his debt to society. So if you are going to put him through any punitive punishment because he's not going to add value to your case, that is a whole different situation that will have something around the corner for you. But the defense have to stand on it. And they have to bring up Bennett. They have to bring up the sexual harassment. They have to bring up the people losing their job. They have to bring going up there and being afraid to meet them and the different tactics that were used. You got to bring that up. This is a pattern, Your Honor. I need you to understand and recognize the pattern. I understand you were not here, but I need you to know why it's so important and vital to know that this is not just the first one or the second one, and it's not the third. Whitaker needs more pressure to be able to be the referee in the capacity that she is supposed to hold it as a referee. You cannot hold a referee title and be a part of the problem, or you watch you got wind of what the problem is or whatever the case is, and you are still sitting there being naive to it and making calls that you're not going to go back. You're not going to go dig back in, and you have to. You have to. So it's going to be crazy to see which way it's going to be brought forward in the morning and how they are going to deal with that situation and who else they have lined up. I still haven't heard the state come back with a pared down list that they were supposed to do on how many witnesses they have left. I heard them say a few names, but didn't they say that they got it down? What was the last number? Was it 200? I believe that was the last number. I think it was 200. But to consider that you have 200 more witnesses and you are sweating a lay witness this bad to come testify and can't give them a week or two to recover and call some of your other 200 witnesses during that process is crazy work. That is crazy work. That you honestly thought that there was no time for him, and you don't even know if there's going to be a jury on Monday because I guess the jury was sick or had somebody sick and couldn't finish their day on Friday. So, what did they ask on record? Will they know Sunday if the jury was going to be in the next day or they have an administrative day again? So, you still, even adding that factor to him, still made the decision to arrest. You don't know if you're really going to have a jury tomorrow due to the issue on Friday. You know he was just getting discharged. You know of his medical condition. You know he had a couple transfusions during this visit. Ain't no way. But you have all these witnesses. You could have called one or two or three, depending on how fast they were, and could have allowed him to heal. But for anybody to not see that she took on a medical liability for them um to say like we'll put you back in here, you don't play with us. But that's abuse of power. And that's what y'all are seeing. Y'all are seeing multiple examples of abuse of power. I don't know. They have to present it a different way. But I don't feel like it should just be a statement or two and then they sit back down. And when Whitaker throws off situations like, well, I don't believe so, or whatever, you got to come back with that case law harder. I think Steele said it best when he was like, I don't understand most of your rulings. I mean, that's legit. I don't think the nation understands most of them. And looking at her, it seems like more so Thursday, Friday, Monday, Tuesday, Wednesday. I didn't get that feeling from her because she kept on being an extension of love with and Hilton leaving comments. But then it seemed like Thursday, Friday, she just came back blowing again. But it's like she got a lot of air, but it's not hot enough to put something down. D said he finds a lot of what she says interesting. Yeah, that was exactly that's exactly what he said. But it is true. I mean, some of her thought process on some things is like, oh, where you get that from? And you can't say it's because she's done appellate court before. I mean, still does appellate court all the time and still. Do you remember what she said at the beginning when she took over the trial? She said something, it's been a while since she had did something. I don't know if she said a criminal case. I can't remember exactly what she said to the effect. I have to go back and see what that comment was, but I was like, ooh. I know I was like too confused off that comment. I can't remember exactly which one it was, but it's gonna be it's gonna be interesting to see how it's handled. But they have to put the foot on the necks. Defense has got to speak up. Um, and if it is shut down, you got to bring it up again. And you got to just hit it with the case law. And you can't argue and you can't go back and forth when it's case law there. That shuts down all that little information, belief, and theory. That case law shuts it all down. D says, I think it was a trial with that many people. No, D, it was something to the effect that it had to do with litigation. I don't know if it was criminal or I don't know if it was RICO. I'm gonna have to I'm gonna have to see. But she blew a lot of hot air coming in, laying down all those rules that she just allowed. Love been trampling over them rules left and right, boy. She been trampling all over those rules. Like, yeah, I ain't turning that over. They're crazy. I ain't doing that. They can wait. If I put it off, they'll forget about it. That's exactly what's happening. And she carries that attitude with her on her chest, on her face, and on her sleeve. It is very easy to read her. And Hilton's body language and her facial expressions just gives her away every time. And you know when love is having a difficult time to explain, she start tugging on her clothes. You start seeing the autonomic responses that you can't help. Even if you try to stop those things, they will automatically happen is because there is a reaction in certain nerves in your body that you cannot control when that part of the brain is activated. And love's ego is going to be shown first before any litigation, before any case law. I thought it was crazy when the judge said, well, it'd be now a perfect time to start entertaining pleas at the beginning. You think they're going to come with a plea? They didn't even respond to that or come back to have any questions. The judge should have followed up 2 days later. Didn't he talk about the pleas? Yes, Slick Whitaker on how she came in blowing the rules down and then allowing these things. I'm saying that the defense has to put it down tomorrow. They're, especially with this what another lay witness, but they took on all these situations with little D and then the connection with Gaither that needs to come out immediately. And now Pops came forward. Pops, I hope you know you might as well go ahead and get witness ready because they're going to call you. You had to talk to lawyers. You had to deal with the prosecution. So the defense is going to take an interest to you because of the things that you have revealed publicly. And you know your son shouldn't be in custody. They let that subpoena expire. I mean, nobody expects a trial to still be going on 2 years and 4 months later. So it's gonna see how they all respond to it, not just one or two. It's got to be the judge's response, the DA, who signed the warrant, what was written on the warrant. Was it exaggerated, falsified? And if it was, what you gonna do about it? You're the referee and you probably signed off on it. So if it's exaggerated or lied on, what you gonna do about it? That's for the defense. Okay, come forward. Let them know about the other warrants. Let them know. Ask about that tap, that phone tap. That warrant come through yet? They're giving too much leeway. You got these type of things happening. Got to keep you got to keep bringing it up. Keep bringing it up. Judge going to be sick of you, but you have keep on saying, well, the more days we keep pushing this off, my client has been inside of this jail that is supposed to be a pretrial detention center that is where everyone in there is presumed innocent, has been held for almost 3 years. So the longer they take in having all these delays in this case, it is playing a mental effect on my client, Your Honor, that we have to talk about. I have to put a motion forward. You got to reverse this and stand 10 toes down and put your foot down. It's like they have Whitaker say something and then they back down or they're afraid. I noticed that the Sharp is delivering most of um, the stuff, but he can get it on cross. But when it comes to addressing that judge, they all got to stand firm and at the same time. Slick said they been said Gaither was dirty. Yeah, I had talked about if you rewind, um, I was talking about, I mean, every hood has them. And Gaither was playing, both sides. And it was a major conflict of interest. She shouldn't have been nowhere near this case through the relationship. This right here should throw out everything because it was a conflict of interest and ulterior motive right there. She should not have had the case. She should not have been allowed to touch the case. She should not have been allowed to go forward. And if she withheld that information, she is no longer a employee there, but she was at the time. In the same way, you could dig back 10 years, 11 years, 12 years, and bring charges forward. What is different for her? And Thorpe knew it. That was his right hand man. So that's his right hand man. You think he don't know that's her nephew? And Slick, I caught that too. So I'm looking at it, from that perspective. There needs to be a lot going on. Is that why the reports, she didn't leave no reports because of those tactics? But you were on nephew real bad. Says Cancer Moon says If they argue back, love will just paint them as sore losers. I think Steele wants to attack the facts of the case because unfortunately you can't overturn a corrupt system as one lawyer. You cannot, but the people can. And I think that's what's being displayed one witness at a time. That's exactly what is being displayed. You can't change a corrupt system, but you have to remember the same system is under scrutiny and under a tight eye from every level up above them. So you're only going to have so many places to run. It's like a box. You can run to one corner for a minute and it slows down, dies down, but in a hot second, you got to get ready to get to the other corner, and you only got four corners to go to. So I mean, when you're exhausting those things, you have to look at that as well. All of these different areas, enough has been put on record being exhausted along the way. And it doesn't matter if anybody looks at anyone as a sore loser, they have an obligation to be able to do it. And they have enough things that are being presented to show that there has been so much prejudice, conflict of interest, and just personal interest, and not the proper procedure followed on investigators' behalf, and it has made the DA to form a case off of theory and belief and whatever they could pull up. And how do you know what they gave? Because the one you depended on was spinning. I mean, your key players to this entire investigation, Slick, you're exactly right. Gaither, Dennis, and Woody. And they're wondering why it's a prolonged case. Nobody put the key elements together. Like, anybody went to chemistry class in school? You start adding it all up, you have to break it down. It's crazy. If you even search up the trial, um, the internet will pull up longest, most expensive in history, and it comes up with all these dirty tactics. And then it goes into Fani's personal situation. It's like, dang, that is what's coming back for your DA's office. You're not changing the narrative, but those people will for you. But it's sad that they get involved only when money's missing. And then you want to be able to hear about all the wrongdoing, but it's being done in front of everybody. But the debrief happened with Steele, and new information, was given more of an update. So it's going to be interesting to see what the Supreme Court comes back with on that aspect. And he's also been there arguing for another case. And so um, it's going to be interesting to see what is going to happen. And he was invited to go do the speech for on election day at the college for, I think it was the Supreme Court or something. He's got a lot of great things happening despite what occurred with him. And I know in his entire career, he probably never thought he would get arrested putting a motion forward. And then you had all of it a secret of where it came out, how it came out, and then it came out. It was the damn investigator in the courtroom telling every damn body. So it's like, one of y'all again. And then you want to go on to the other side on the other trial, and you're thinking everybody got attorneys, And it's clearly on record, their last court date, they were still figuring out attorneys. So how can they say all plea deals are rejected? Hell, you still got two people there looking to see who's representing them. Like, I don't know who stops the circus. It's something, it's just lights out at this point. It's too messy. It's got too many elements that are not adding up. And I'm sorry, but you got to blame your investigators because they were allowed to be being spun, think, oh, yeah, we got something. And then they go spend the resources and the time on it. And they say, we got to go get him again because he played us. And now he'll do it again and you'll fall again. And then you got to spend the whole task to go look for him the next day. It's like, damn, that's a lot of resources you kept on spending, all because you wanted one person. And there's a history. It's like somebody has to put it on the wood all the way out there and call it for what it is. And that's why I said from the very beginning, I bring people on or whatever. I said, I'm not displaying myself. I don't want no notoriety. I don't want no notoriety. I just want people to take the information and help. Look at it from every single aspect and not just from a streamer content aspect. Because at the end of the day, you can put eyes on the trial, you can stream the trial, but when the trial is done, you move on to the next thing. What happens with these families? What happens to these young men? What happens to the stuff that you've seen that weren't right during? You have to wait to undo that in a appeal court, which here it's pages and pages full. And that's why, for common sense wise, any more added resources or resources spent on this case is out of negligence, because this case has more than 10 reasons that would win on appeal on face value. But for them to even waste court time for a RICO and they're going outside of that indictment and they can't, is a whole nother thing on why they're allowing waste of time. So we'll see. It's 2 a.m. Court is 8:30. So in a few hours, court is. I'll try to go live on lunch, on the lunch break, this time, because I am working from home. So I'll be able to jump on, depending on what time they break or what it looks like or what they have. If not, I'll go ahead in the evening, but I always do put up if you put the notifications on, you'll be able to get it. But I'm going to go ahead and get a couple hours of sleep before I got to get up and do it all over again. If you guys have any more word on the curb, let me know. Slick, thank you. You got it coming. I owe you. Mel got me. And D, we're going to see who he chooses. But I hope you guys have a very good night, and I will see you guys back here tomorrow, and we'll see what it is. And I'm going to call it. But what I want to see is the defense, to be able to hold steady and hold strong tomorrow through this and to put it all out there. It is enough that has been announced that this is enough to push forward, and let's start writing the next step up. So this can be handled according. There's been enough games that have been played, enough people have been violated, and at this point, it's lives at stake and sick, gravely ill people being taken in off of malicious intent. So we'll see. We'll reconvene back tomorrow. If I pop up on the news, don't be surprised. You'll know my voice. But we'll see after tomorrow. And we'll reconvene back here. As always, guys, stay blessed and thank you for tuning in. And I hope everybody has a wonderful night and be safe going to and from until we're back here again tomorrow. Have a good night, guys. Bye.